today. Good morning, ladies and gentlemen. This public hearing, sponsored by the Committee on the Guam U.S. Military Relocation, Veterans Affairs, Homeland Security, and Judiciary, is hereby convened. On the agenda today, on Thursday, April 3rd, 9 a.m., we do have bills, the following measures that will be entertained. Bill number 280, which is relative to bias-motivated crimes, sponsored by Senator Tony Ada. Bill number 282, which is relative to the crime of burglary in schools, which may be cited as the Safer Schools Act of 2014, sponsored by Senator McCready. Bill number 296, relative to concealed firearms licensing, sponsored by Senator Tony Ada. And we will close out with Bill number 298, relative to punishment for delivery, dispensing, manufacturing, and importation of controlled substances, which may be cited as the Methamphetamine Incarceration Reform Act of 2014, sponsored by Senator McCready. Just for the information of the public, the notices as well as the print was, this particular public hearing was noticed in print, dated Thursday, March 27, 2014, and likewise on the very same day, the notification to all the stakeholders, inclusive of the media, and I would like to, in particular, thank the media sources out there for assisting in disseminating this particular information. The initial public, the notification to stakeholders was shortly released thereafter, and then the second print was released on March 31st on Monday with regards to this public hearing, and then a subsequent notification and a reminder was presented to all the stakeholders dated March 31st. So like was mentioned a little earlier, we will proceed in the sequence according to the agenda, and the first bill that will be entertained once again is Bill number 280, which is relative to bias-motivated crimes, sponsored by Senator Tony Ada. But before I allow him to provide some brief comments in regards to this particular measure, I'd like to thank my good colleagues for joining us in the public hearing this morning. To my immediate right is Senator Tom Ada. To my immediate left is Senator Tommy Morrison. To his immediate left, Senator Chris Duenas. To his left is Senator Brian McCready, and then to Senator McCready's left is Senator Tony Ada. So for all those who have signed up for Bill number 280, of which I believe we do have Mr. Deputy Chief of the Attorney General's Office. Jill, if you can please join us at the panel, and in the meantime, we'll go ahead and allow Senator Tony Ada to provide a description of the measure. But before, once again, I proceed in that direction, I'd like to recognize Speaker Ben Pangilinan. Thank you very much, Mr. Speaker, for joining us this morning. Senator Tony Ada.
Thank you, Mr. Chair. Just a brief on Bill 280. And what the bill does is that it defines and punishes bias-motivated crimes. And good morning, and thank you again, Mr. Chairman. And bias-motivated crimes are violent criminal offenses involving bias against a person or group because of such reasons such as ethnicity, disability, religion, and sexual orientation. No one should be a target of a crime simply because he or she is part of a certain group. The victim suffers, the victim's group suffers, our island suffers. And Bill 280 seeks to set as a deterrent to this type of crime. Thank you, Mr. Chair.
Thank you very much, Senator Tony Ada. Mr. Tydinko, if you can please identify yourself for the record and proceed with your testimony.
Good morning, Chairman Aguon, Senator Aguon, Senators Tom Ada, Senator Ben Pangilinan, Senator Tommy Morrison, Senator Chris Duenas, Senator Brant McCready, and Senator Tony Ada. Phil Tydinko, Chief Deputy AG, on behalf of Attorney General Rapadas and the Office of Attorney General. With regard to Bill 28032, of course we support the intent to try to address those kind of crimes that may be based on what do you call unconstitutional bias, motivation, hate, also known as hate crimes. If I think this is what the bill is intended to try to cover, one could characterize it as a statute to try to address hate crimes, and certainly we support that concept. I think the best input that I would like to just give today is that our office is just asking for, and I know there's probably 10 days after this public hearing, we just need some time to digest the drafting and the elements of this law so that we can try to see whether there are any potential inconsistencies or constitutional issues regarding, for example, I was just trying to understand the function of the penalty enhancements, whether this statute's intended to be tied to, it starts out with the institutional vandalism, so is the hate crime based on institutional vandalism, but then this bill goes on to talk about penalty enhancements for crimes against a person's body. You know, that's why they cite 16, 19. Those are assault, murder, rape, and so forth. Those statutes. So our input here is that we need a little bit more time to look at that. Otherwise, certainly we support the concept to address this area, and we should have it on our books. You know, there's always that concern that can come up. There are circumstances, even in our community, where there is ethnic or racial bias that some people claim exist, and so whenever you have people who belong to underserved or underprivileged or less socioeconomic, and sometimes are the unfairly blamed for larger problems, even though they may contribute to it. Certainly having this kind of crime on the books would help address those circumstances if the evidence if the police were to uncover that kind of evidence that the motivation behind crimes committed against a particular person based on their race, ethnicity, religion, and so forth were evident. So again, we support the concept, and so that's my input, but we just need a little bit more time to see whether there are any legal issues. We just wanted to vet it a little bit more. Thank you.
Thank you very much, Mr. Tadinko. Just also for your information, a copy traditionally of all of our public hearing notices are forwarded to the Attorney General's office for his initial review before we conduct the public hearing. So, yes, you will be granted the additional 10 days for any additional comments or written comments you would like to provide to the sponsor of the measure. Senator Toledano?
Thank you, Mr. Chairman. I'd like to thank the AG's office for their participation in this bill, and also we look forward to continuing working with them on the markup and any suggestions that they may see to include. Thank you, Mr. Chair.
Thank you very much, Senator Ada. Senator Pangilinan, do you have any comments or suggestions?
Thank you very much, Mr. Chair. I do kind of share some of just the reconciliation issues I think that needs to occur with regards to bias-motivated crimes. As the Attorney General had mentioned, the hate crime statutes are usually against persons and not buildings, and so how does one reconcile that with existing federal laws on those issues? And I think that's what that's what we find in our committee when bills are introduced, where they kind of get introduced out there without some of the background work, and of course we depend on the public hearing process to ferret those out. But from our committee, we also depend a lot on the author to take some of the feedback from the public hearing and resolve those issues before the committee moves on the work. And we find that we have to do a lot of that, and sometimes bills are left in the committee waiting on the author to resolve some of those issues when the committee feels that it doesn't understand the author's intent. So my suggestion would be not only will the committee look at this, but the author should kind of take some of the input here and try to work with what input has been given to respond to some of these questions, and that assists the committees, not just committee, but I think all the committees of the legislature in moving some of these bills forward. If we kind of have to wait and do the work ourselves, we can't read the author's mind based upon the public input that has occurred, and we don't want to, at that time, if the author is not willing to give up what his intent is and leave it to the committee to determine that, then I think they need to come back to the committees with some of these input. And so keeping the record open, continuing the hearing to continually receive these until the committee and the author are satisfied that whatever uh, smoothly on the debate on the session floor, in which the bill reflects the intention of the author, even if it's amended out of committee. So that's my suggestion in terms of what should occur in some of these processes. So thank you very much, Mr. Chair.
Thank you very much, Speaker Pangilinan. And on that note, the committee will continue to receive testimonies on Bill number 280-32LS for the subsequent 10 days from this public hearing date. And the committee does reserve the right to continue this hearing within that 10-day timeline so that, in fact, the public is exposed to any changes or amendments that may be significant in nature. So, yes, Mr.
Yeah,
Delegate.
if I could just add one more point to make with regard to, yeah, we will contact, of course, Senator Tony Adam. We work very well with him in working and vetting these bills, so we'd like to know where the origin of the language and which jurisdiction it came from. But and even though I can't speak for the Guam Police Department, I noticed that there's a requirement for bias crime reporting and training, and it's mandatory. If I were their legal counsel, I would request that you change it to may establish as opposed to shall, because it appears to be an unfunded mandate, and hate crime or bias crime training is rather sophisticated, and you would probably want to invite like the FBI guys or Department of Justice guys to try to. I don't think we have anybody that's an expert in providing that training, and it looks like it would be because I know what's going to happen. GPD is going to call us up and say, "Do you guys have the ability and resources to do this type of bias crime reporting and training and maintain a repository and all of that?" Those mandates, and as you know, these impact budgets. So, and it probably impact both our budgets. Although it puts the onus on GPD, I would respectfully request that you make it permissive at this time, in terms of priority. I'm referring to page, section 72-105. It says bias crime reporting and training. I just request that that you make it permissive at this time, unless it's funded. Thank you.
Thank you very much again, Mr. Chief Deputy of the Attorney General's Office, Mr. Tadinko. And once again, like was mentioned a little earlier, the committee reserves the right to, or will continue to receive public testimony, written testimony on this particular measure 10 days subsequent to this hearing. And once again, does reserve the right within that 10 days to call a subsequent public hearing, continuation of this public hearing discussion, should there be any significant proposed amendments in regards to this measure. And that same continuance provision would apply to all the legislative measures that are being publicly heard today, specifically because they deal directly with individuals in the community and the public safety. So that being said, we're moving forward to Bill number 282, which is relative to the crime of burglary in schools, which may be cited as the Safer Schools Act of 2014. Mr. Tedinko, I believe you have also signed up for this particular measure. And Senator McCready, the sponsor of the legislation, you may proceed with your comments.
Thank you, Mr. Chair, and thank you, colleagues, for being here this morning. Bill 282-32 is also known as the Safer Schools Act of 2014. Establishes a sentencing enhancement for those who burglarize schools. Under this bill, burglary committed at the school is a first-degree felony that carries a minimum sentence of 10 years with a maximum of 20 years. We must protect the infrastructure of our schools to ensure that our students aren't robbed of an education. Now, these laws haven't been updated and amended in decades, and the climate of crime has risen exponentially. This piece of legislation reflects that and amends this bill to reflect the crime of 2014. Thank you, Mr. Chairman, and I look for support from my colleagues. Thank you.
Thank you very much, Senator McCready. Mr. Tedinko?
Again, thank you, Chairman Aguon and Honorable Senators. Phil Tydinko on behalf of Attorney General Rapadas and Office of Attorney General. Certainly the concept of making our schools safer is important, and we support that, and as does everybody, and we recognize the frustration for all people who have children attending these schools when these schools are burglarized and vandalized, and certainly the general principle that increasing penalties does serve as a deterrent. And these are policy calls that the legislature can choose to make. What at least some of my prosecutors asked to point out, it's more of perhaps a rhetorical question, but it's something that as policy makers, you folks need to wrestle with, and is that increasing the penalties here of a burglary committed at a school to a first-degree felony with a minimum mandatory of 10 up to 20. Our question that we wanted to present at the public hearing is why is that any more heinous than having your own home invaded by a burglar? Because right now the statute provides for a minimum mandatory 5 years when someone burglarizes your home, and usually, our castle is sacrosanct. And if the policy is that the schools are sacrosanct, then very well. We just wanted to pose that question to you folks as policymakers, that the school, increasing the penalties for the school would appear to put it above the invasion or burglarizing of our homes, our castles. So that's a major policy shift in terms of values and morals of our community. So again, that's for you folks to answer. I mean, we'll just carry out the law, but it may make our jobs harder because we have to wrestle with our prosecutorial discretion when we try to plead these out, So the other issue impact, of course, for the juvie section is that, as you know, our statute currently provides that that minors, if they're charged with a second-degree felony and higher, and they're 16 and older, they're automatically certified as adults. And so the schools tend to be, and I could be wrong, maybe the GPD can provide more light on the facts, and this should all be factual driven and empirically based. But if the minors, we might find more minors certified as adults, and maybe very well they should be if they're repeat offenders, certainly. Maybe they should be punished more harshly. I don't know. The statute kind of does that already. If you're a first-time offender, which is usually the reality, at least based on my 25 years almost in the area on both sides, is that by the time we catch the minor or the children burglars, it's only their first time. Not to say they haven't done many. The saying is that for every time we catch a burglar, he's probably committed 50. Or whatever the number, just repetitively. So again, it's more of we want to raise that to the level of awareness. At the same time, we do understand that it also, on the other side of the coin, when the schools are burglarized and vandalized, the impact is even wider than simply one's home. I mean, there's 28 kids in that classroom that are out of school, losing their education. Their parents are depending on those children to be educated, and it impacts the teacher, the school, the community. So you need to balance these issues and these values. So we just put that out there, and that's our input. Thank you.
Thank you very much, Mr. Tediko. Before I yield the floor to the sponsor of the legislation, just to follow up on your comment with regards to minors. So this particular provision would directly apply to minors should any individual be convicted. Is that your interpretation?
The Title IX, all minors can be charged with Title IX crimes.
Mm-hmm. So minors, yes. Anyone below the age of 16.
Well, yeah, but then but it's not an automatic certification. Our statute says anyone that's under 16 who's charged with a felony or greater, then the prosecutors or the juvenile prosecutors or the adult prosecutors would have to prove to the court why we should try someone under 16 as an adult. And there are many circumstances and cases which you would not, because of the tenderness of the age and other circumstances and the empirical information and data that the psychologists or psychiatrists or school people or and then the family court judge would look at that, whether he would authorize a certification. So we have built-in safeguards for that. I'm just simply saying that typically the youthful offenders above 16 would probably be automatically certified as adult. It's an impact, and that may be fine as
that
a
aspect I
policy
understand.
call.
But just so that I don't venture into anything that just recently surfaced, let's say if by any chance a 12-year-old were to be convicted of this particular burglary.
You mean if they were certified as an adult?
No.
Oh no, they'd have to be.
There are statutes that.
Yeah,
that would
if you're under,
segregate.
the way our laws is set up, if you're under 16 and you're charged with a felony in the second degree or greater,
As a minor.
then the government must prove to the court why you should be certified and treated as an adult and tried in adult court and punished as an adult, whether you're 5 years old or 15 years old. We would have to prove to the court why you should be certified. So that's the safeguard. I don't think you have to be. That's a safeguard that's built into it. I don't think that statute affects. The statute affects it. I'm talking about the ones who are 16 and above, who will be automatically.
Yeah.
Yeah, between 16 and 18, they would be automatically. Well, actually, between 16 and 17 years and 364 days or whatever. That group would be automatically certified. That's an impact, okay, but not to the. It wouldn't be any different for anybody under 16. We'd have to go to court and be able to prove why we want to certify them as adult. And usually we reserve that for more heinous crimes. Usually it's in the homicide area that or that we make those considerations, or the person is just a repeat offender.
I guess the primary reason why I pose this question is obviously if an individual is a minor and is convicted of this particular activity.
If they were certified as an adult and they were convicted, yes.
No certification,
Oh.
just convicted as a minor
You-
of having
Convicted as a minor in juvie court.
in juvie court.
Yeah, but juvie court maxes you. You can't go above the 21 age ceiling on being incarcerated.
Okay, and like I said.
So for example, if you got charged with this crime in juvie court, and you were adjudicated, I forget the terminology. They don't like to use the words guilty, but if you were adjudicated as sort of guilty of it, the maximum I believe you could serve would be 21 years anyway, and then you're let loose because you're no longer under jurisdiction of family court and DYA. So that's another built-in safeguard. You wouldn't do the same kind of penalties. There's already a built-in ceiling there.
Okay, my biggest concern is looking at minors and making sure that we also look at them from the correctional perspective and not necessarily.
If they're tried in family court, then that's already built. It should be institutionalized in the family court system. The sanctions that are imposed by the court are with rehabilitation in mind, and it's mandated. So that's covered. I mean, you could still be charged with this, but you would face the consequences of family court and DYA. You wouldn't face the consequences of adult court.
Okay, thank you very much, Mr. Tadinko. Senator McCree.
Thank you for clarifying that, Mr. Tadinko. And that was one of the issues that when I was constructing this bill that we focused on was the minors and the adults. And so it's my impression that we don't have to put specific language in there because you already said that there's a safeguard already in place. So is that my understanding right now, is we don't have to put specific language to dictate the age group that this bill would affect because the safeguards are already in place?
Right, except for the impact, yeah.
Okay.
Right. For example, if a 13-year-old committed a burglary or 10-year-old committed a burglary, they would be tried in
juvenile
in family court. Okay, unless the prosecution, the AG's office, made a decision to try to certify that person as an adult. And again, that would require a whole due process hearing and trying to convince the court that it's in the best interest of the child and the territory, which I don't see how it's in the best interest of the child, but for a burglary committed on a school, they're certified. And certainly I just see former Chief Justice and longtime family court judge B.J. Cruz could also confirm my responses about that. So again, the impact that Senator McCree that I was, at least on juvie court, was that for those who are 16 and above, that's a right-of-way impact right there. But even more fundamental is you're raising the crime of burglary as higher than the crime of burglary upon our homes, and so we just wanted to make certain that debate occurs. Thank you.
Thank you.
So would
very
you
much,
say
Senator.
one more question? So on your last topic, so would you say then to parallel the burglary, the home burglary, to reflect the same as the school burglary?
No, I think the burglary statute as is workable. It's because the current burglary statute, like if you're asking me for a suggestion, if you wanted to target those specific burglaries, then I would, you might want to make an enhancement. But the burglary statute on its face allows prosecution to deal with first-time burglars and not put the minimum mandatory 5. And if you're a repeat offender on your second burglary, then you have to serve the minimum mandatory 5 up to, I forget what the other range, 10. But now this proposed bill seeks to punish burglary committed at school with a punishment range of 10 to 20. And I'm just simply pointing out that the setting, if the setting, well, anyway, that's a discussion you folks have. If I was to give a suggestion, I might say, well, rather than create a separate crime, you might want to make it as a special allegation enhancement, just as something that the prosecutors may consider using or not, kind of optional, as opposed to being placed as a new crime. Because what you've done and what you're proposing is creating a new crime of burglary based on the setting, which is the school. And again, I'm just asking, is the school setting more sacrosanct than the home?
Thank you very much, Senator McCree. To Speaker Pangilinan, I'd like to recognize the presence of Vice Speaker Cruz. Thank you very much, Mr. Vice Speaker. Speaker Pangilinan.
Thank you very much. I just want to be very clear, Phil, because I think we're kind of going back and forth between the 13-year-old and the 16-year-old. Under this statute, under the current statute, a 16-year-old gets automatically certified as an adult for the commission of a crime. And so under this statute, and right now, that 16-year-old, if convicted, would serve 5 years or a range of 5 and so forth, depending on what you charge them with.
Right. And
right. So this now,
if he was a repeat offender, yes.
Yes. So this would make a first-time offender, 16-year-old, first offense, broke into a school, one school, that he would automatically, if convicted of that, now serve 10.
Yes.
So now we're going to put our 16-year-olds who commit one crime, under any circumstance, automatically he's going to be in jail till he's 26. No chance, no rehabilitation, no circumstances. So I think that's the debate that has occurred, because that's the group that's affected by here. And I'm sure we go to GPD, you're going to find that a large portion of these children, of these burglaries at the schools, are these kids. They're not adults. They're not 21, 50, 30-year-olds. They may be there with the 16-year-old, but they are accompanied by that individual. And so the debate is do we want to send these first-time offenders, immature 16-year-olds, and have them mature in a setting of hard crime? I don't know. That's the debate that has to occur, as you said. The other thing is, of course, the school. Is it more sacrosanct than the home? Isn't there already, Mr. Tadinko, a statute, and I think it was introduced, may have been introduced by the current Lieutenant Governor, of crimes against public facilities. I think that bill was passed, debated on. The debate we had was, is it more important than our homes? The same debate that occurred when there was a lot of thefts against the generators that were being put out there. And you saw the generators being ripped off of the cable and things like that. And I think somebody introduced the bill, and I think it's in statute, and it's crimes against public facilities. So wouldn't this be covered, except for the portion that covers private schools and gyms and things like that? But isn't there something in the statute that enhances the crimes against public facilities?
I don't recall that particular statute. I do know that the only thing that comes to my mind is crimes against community, but I can't recall if we have on the books crimes against public facilities.
I think it's crimes against the community.
It might have been the crimes against
But
community, which was for the copper
crime
thefts.
against the community is a crime against the facility, owned by the community, because that was the debate that was occurring. And so instead of making it specific to generators, the water wells, I think the bill was kind of expanded to say crimes against the community, and then the AG's office can decide that if you commit a crime in the school, that's a crime against the community, and there's an enhanced charge or punishment there. And I think, once again, we need to kind of, drag in those issues, have the author, kind of facilitate the discussion on this with your office, make the necessary changes to meet his intentions, that he in fact wants to send these immature 16-year-olds who commit their first crime to 26 years, till he's 26 at DOC. And that's the debate I think that should need to occur from a policy level. Is the home less sacrosanct than the school? That's the debate that needs to occur. But we want to make sure that whatever comes out of the committee meets the intention of the author. And I think, that needs to occur. And again, I can't overstress that from my perspective on how I operate a committee. I want to make sure that, if the author wants to continue to work with the bill to meet his intention, if he doesn't anymore and he's just satisfied with introducing the bill and not wanting to do any more work, the committee will happily take it up. But I think that needs to occur, and the author needs to be involved in that process and respond to the hearings to the comments that are presented at this hearing, and not depend on the committee to do the work for him. I think that's very, very important.
Thank you very much, Speaker Pangilinan. Senator Duenas?
Thank you, Mr. Chairman. I got a question for you. I just also wanted to thank you at this point on a bill that I've introduced that's has its public hearing has been so heavily stated here. I sure hope I get that opportunity, and you get an opportunity to read in the testimony your already testimony that you've testified on a bill that I've introduced recently. So I thank the chairman. I want to do the work. Got to hear the bill first.
Which bill is
It's
that?
a different subject, but
Okay.
That bill will
on,
get
on the land.
If I have this, what do you call, puzzled
Yeah.
Deer in the headlights
But you-
look, I'm like,
but you had a great.
what, did I say something
You had
unfavorable?
Patrick Mason had a great response, and I
And the
just can't
committee
wait
has
to
not
have
had
that
a hearing since that bill has been introduced. So it's not that we're not hearing his bill specifically.
It's been a
The
couple
committee
months.
yes, absolutely. The committee has not had a hearing for a couple months.
Let me
Thank you.
say, I hope it was a constructive response. and-
Thank you, Mr. Chairman. I heard in your testimony, Phil, somewhat that what I was concerned with is it sounded as though what you were discussing was that it may encourage the way it's being introduced may encourage a waiving to the is that what I heard?
I'm sorry, encourage a what?
In terms of this, if this were to become statute, that's what I was concerned with too. It sounded like you were saying this may encourage waiving minors to the adult system. Is that what your testimony was in the beginning?
No, it's not. It's not encourage. It's
Okay.
just our laws, our criminal justice system is set up that if anyone 16 years or older commits a crime as a felony in the second degree or higher, that person is automatically certified as an adult.
Okay.
And so if you create a crime called burglary against a school is punishable as a first-degree felony, then conceivably the 16-year-old would be automatically certified as an adult for a first burglary against a school offense, as opposed to right now, we could charge that 16-year-old with burglary, but if it's his first offense, then it's likely that we'd drop it and leave them in family court jurisdiction as opposed to trying to automatically certify them. So I'm just saying that that's the impact that this would have for that group of those between 16 and just a day under 18 years old.
Okay.
Obviously, if you're 18 and above, you're already an adult. And so that's the impact that that we were just sort of we saw, at least the prosecutors saw that as a potential issue, and certainly that's a policy call that the legislature may make. I know that there's feelings on both sides of the issue. Maybe they should be. I don't know. I don't think so, though. We like to believe that that our minors are rehabilitatable, except where I guess where they become clearly there's recidivism. But again, this would affect even first-time offenders or arrestees or what have you.
No, I agree, Mr. Chairman. I mean, Mr. Attorney General, I spend a lot of my time doing that, so that's why I'm concerned as well by your comments. I think maybe the author could have the opportunity now to go back and still maintain the intent of this by shielding that issue, maybe by amending current statutes.
You can.
So
As I say, you could.
I'm sure
you
he'll
could
work on it.
You could tweak that. You could. We could carve out that exception. I mean,
Sure.
But again, but even more fundamental is just the issue that we thought the debate should be about increasing penalties based on the setting,
Right.
as opposed to what we have on the books.
Okay. Thank you, Mr. Chairman, and thank you for your testimony.
Thank you, Senator Duenas. Senator McCready?
Thank you, Mr. Chairman, and thank you, my colleagues, for the testimony. And I just wanted to the letter of the law, because Senator Pangilinan used children as his reference. The letter of the law, 16-year-old is not a child, correct?
Well, I mean, as I understand the legal definition, it's minor children. So that's anyone under 18.
Anyone under 18.
Right.
Okay, so anyone above 18 would be considered
An adult, right.
And if the
18 and above is an adult.
And if the intent of this bill was not to put a 16-year-old behind bars for 10 years, is there some kind of language we can add to then say that maybe the judge would have the authority to decide the sentence, that enhancement?
Well, Senator, I think we could offline or in a roundtable we could discuss again carving those exceptions. Whether you want to again leave that area to the discretion of the judiciary, or is that because then you're talking about is that an executive function, and do we have a separation of powers issue? I don't know, but I think the easiest fix would be if you want to carve an exception, it's easy to carve an exception.
Okay, and you said earlier in your testimony that
without without involving the judiciary, we can just carve an exception to that if you want that.
And last question, you also, Senator Pangilinan said that the 16-year-old gets caught for the very first time, we're sending them to prison for 10 years. But you said earlier in your testimony that just because you catch him for the first time, it usually means that he's committed 50 before that.
Well, yes, I was embellishing that's a common feeling that some burglars are not being caught for their first time.
Okay.
So you're right. There are many cases in which by the time we catch a burglar, they've committed multiple ones, and I apologize if I embellished with that number. I just wanted to emphasize the point what you're trying to emphasize is many times by the time a person's caught on their first one, it's not their very first one. That's my personal experience. It's not empirically.
But it's not evidence-based.
That's just my personal experience for whatever 20-something plus years counts in law enforcement, and of course prior to that work, I've been a probation officer and mental health worker and social worker, 15 It's not data-driven. That's just personal experience.
Thank you. And that's my final question. And I just wanted to make sure some of those things were probably, because I don't want to get the impression that we're soft on crime, because we're not. I just want to make sure we do give these people the opportunity to rehabilitate themselves. I think it's very important. But at the same time, I think we should administer tough laws that send a message that incapacitation is a form of deterrency when it comes to enhancing these penalties, and we're not soft on crime.
We agree.
Thank you.
But this bill as written is hard on children.
Thank you very much, Senator McCready and Senators. Senator Morrison, any follow-on question?
Yes, thank you, Mr. Chair. Mr. Tedinku, thank you. I've been trying to process everything in, and again, I appreciate the author trying to do something about this. We've passed legislation to put security cameras in almost every school out there, and this incidents are reoccurring. I know you brought up earlier some of these cases, and I'm not sure, correct me if I'm wrong, some of them have been minors, right?
Yeah.
I mean, of course, there's a recent one, and I'd like to know, you said a lot of times it could be their first time, but have you dealt with some of these cases that are coming before you that have been repeat offenders?
I think I answered that question based on my experience. Yes, and of course I'm sorry to see that your colleague had to step out. I think Senator Duenas could give you much more better empirical information than I did, because he served as director of DYA, and he can tell you firsthand, having read all those files during his tenure, whether that's true. And I would venture a educated guess that he would say yes, that's true. There are many who are who committed multiple ones before they were finally caught. But I think he might also point out there were many who are just first-timers too, who may have been so inept that they got caught at their first one. So I believe he'd probably be a better source than I am. I mean, you know, I'm a glorified office manager these days, so I'm not in the trenches as much as other folks. So that would be my answer.
Is there any cases that you've dealt with, or anything that you know of that under 16 are serving for these types of crimes, or specific to vandalizing of schools?
In adult prison?
No. Yes.
I can't think of any.
Okay, so
For burglary, I can't think of any. I cannot think of any at this moment. I'd have to go back to the office and see if there's any. I do not believe so.
Is there any under 16s serving in juvenile crime up to the age of 21?
Yes, there are some that
Okay.
that may be yes.
For these types of incidents?
Not necessarily for burglary. They might be doing it for more heinous crimes. There might be some repeat offenders, but it's usually for more serious type of crimes. But it's possible. I wish I had Carol Hinkle Sanchez, because she's the head of the juvenile prosecution unit, and she could probably give more specific information, and we can get that information to you.
Okay. Thank you, Mr. Chair.
Thank you very much, Senator Morrison, Mr. Stadinko. Just for the record, the committee did receive written testimony by Mr. John Fernandez, who's the Superintendent of Education, and contained within his testimony, he highlights that the Guam Department of Education has thus far in this current school year realized 39 burglaries, and in comparison, school year 2011-2012, there were 86 burglaries, and in school year 2012-2013, there were 40 during the entire school year. Once again, the committee will continue to receive testimony subsequent to this
Senator,
particular.
if I may just add an
Yes.
information.
Speaker Van
Yeah,
Gogh.
we were discussing if there's any existing statute. There was Bill number 38 passed into law as Public Law 28-39, introduced by now Lieutenant Governor Ray Tenorio and the Chief Justice B.J. Cruz. And there was the crime against the community, which includes crimes against schools, public services, students, or any government service intended to benefit the public, and any interference with that operation well that may be imposed on these individuals. So there are existing statutes that cover public schools and public facilities on this type of what this bill is proposing. So I just wanted to bring that to your attention, so you don't have to go looking for it. And it's yes, you got the title right, and it's 4331 of Chapter 43 of Article 1, Title 9, Guam Code Annotated.
Thank you very much, Speaker Pangilinan, for that information, and thank you again, Mr. Tadiko, for your testimony. Once again, the committee will continue to receive testimony, written testimony on Bill Number 282, that's 32 COR, subsequent 10 days subsequent to the date of this public hearing, and the committee continues to reserve the right to call a continuing public hearing within that 10-day time frame. We're going to move forward, proceed with Bill Number 296, that's 32. Ladies and gentlemen, we do have a good number of individuals who have signed up for this particular measure. And Mr. Dadinko, I think that I found your name on the final sheet. So we're going to go based on the lineup of individuals who have signed. So I would like to invite the following individuals to the table, please. Robert Gibbons, Kenneth Gibbons, Gary Hickenbottom, Darren Alvarez, and Romeo de los Santos. Once again, gentlemen, if I can invite you up front, Mr. Robert Gibbons, Mr. Kenneth Gibbons, Mr. Gary Hickenbottom, Mr. Darren Alvarez, and Mr. Romeo de los Santos. And then we'll... Okay, but he is allowed to sign the roster sheet expressing his support for the measure. Is that correct? Yes. That's it, but not providing testimony. Okay. Then understood. Then can I invite also Mr. Stanley Wilson and Brian Schnabel? Is there Brian Schnabel in the audience? Scheibel? I apologize if by any chance I mispronounce some of your names. And because there's an extra seat, can I invite Jason Young to the front? Okay, and then we do still have a few other individuals who have signed up. If we can begin with the sequence of names that were called a little earlier. Mr. Gibbons, Robert?
You want me to go ahead and, Mr. Chair?
Oh, I apologize. Let me allow the sponsor of the legislation to be able to provide some comments. Bill Number 296, which is relative to concealed firearms licensing. Senator Tonietta, if you would like to provide some comments.
Thank you, Mr. Chairman. Thank you, Mr. Chairman, and thank you again for including Bill 296 in today's hearing agenda. The co-sponsors of Bill 296 and I believe that the right to bear arms includes the right to carry a concealed firearm. We believe that Guam's firearm laws do not recognize this, since an applicant for concealed carry must show exceptional cause to have a permit. Further, the determination of who can be granted a permit rests with one person. The fact that a person carries a large sum of money should not be given more weight than a law-abiding citizen who wants the protection that a concealed firearm affords. While some may argue against any government regulation of a constitutional right, I believe that certain controls must be implemented on the issue of who may legally carry a concealed firearm. These controls must be clearly stated in law and not be subjective. And this is what Bill 296 seeks to do. Thank you, Mr. Chair.
Thank you very much, Senator Ada. Mr. Robert Gibbons?
Thank you very much. Thank you all for coming.
Morning.
I actually signed up as a supporter. I didn't check that I was going to speak. But the only thing I'd like to say is that in the existing system as it is, I have in the past on 2 different occasions had concealed firearms ID. And when I went to renew it the last time, it was denied the same justifications as previously. And I mean, it's just the system today seems to not have any continuity. It's difficult, and the police cannot be everywhere. You know, I'm not trying to be a cop. I don't want to be a vigilante, but I do want to be able to protect myself. And with the crimes that are happening lately, you know, you've got these guys with the punch-out stuff that's happening. I mean, walking on Tumon, people are getting assaulted. I feel I have the right to protect myself and my family.
Thank you very much, Mr. Gibbons, for providing your testimony this morning. If I can ask you to, we'll start from the left, your left, and going to your right. But if I can ask you to please identify yourself for the record initially and then provide your comments. Sir?
Afternoon, good morning, Mr. Chairman, honorable senators. My name is Kenneth Gibbons. I'm the president of the Guam Gun Owners Association. I've come here this morning to share our views on Bill 296. With how our crime rate has skyrocketed in the last 18 months and with 9 homicides in 2013 alone, we feel law-abiding citizens need to be able to protect themselves and their families. Our outstanding officers of the Guam Police Department, through no fault of their own, are unfortunately not able to be everywhere at the same time. We as citizens need the ability to protect ourselves outside the home as well as inside. Currently, Guam has what is known as a May issue concealed licensing system. That means the applicant must show exceptional cause besides just personal protection or self-defense, so that the applicant may be issued a concealed firearm identification card. The decision solely rests with the Chief of Police. He and his staff make the determination whether or not the applicant may have the permission to carry a firearm concealed. Unfortunately, there is not always consistency with how permits are issued. As an example, I myself applied with another colleague a few years ago. We filled out the identical exceptional cause or reason to carry on each application, short of the name and address, of course. I was approved while my colleague was denied. Maybe it was something in his past, you say? Now let me share with you that both of us were at the time federal law enforcement officers. Obviously, we both had been through extensive background checks in the process of our employment as sworn federal officers. This subjectiveness in the decision process allows for inconsistencies in the approval of concealed firearms ID applications. Bill 296, the shall issue law, changes that by establishing a set of requirements which must be met in order to obtain a concealed firearms ID. Bill 296 is modeled after the shall issue concealed carry law passed in Florida over 25 years ago, 1987. That law has allowed many law-abiding citizens to carry a concealed firearm legally and have the ability to protect themselves and their families if they or their loved ones face serious bodily injury or death. Bill 296 stipulates detailed criteria that citizens must meet, such as being a non-felon, no history of illegal drug use or domestic abuse, and must be mentally competent. It also requires that to get a concealed firearm, the applicant must show competency with the firearm by showing training has been completed, whether given by the military, police, or civilian accredited course. The applicant obviously must be able to legally own a firearm here in Guam before receiving a concealed firearm ID. It does not allow citizens in any way to act as police officers, vigilantes, because they have a concealed firearm ID. Nor does it change any of the self-defense or deadly force laws if someone is forced to use their firearm. Deadly force should always remain an absolute last resort, as it currently does in Guam law. This bill doesn't change that. Florida's law served as an example for other states, and now 41 out of 50 states, that's correct, 41 out of 50 states have shall issue laws, allowing their citizens to lawfully carry a firearm in accordance with the Second Amendment. At this time, there is an estimated 10 million concealed carry permit holders in the United States out of approximately 280 million. That is proof that people are not misusing their concealed permits on a daily basis. One of the biggest reasons people are normally against this idea is that they think there will be blood in the streets and Guam will become the Wild West. This can't be further from the truth. In each of the 41 states with these laws, dire predictions of gunfights in the streets also were brought up, and once the laws passed, none of the bad predictions took place. In fact, crime rates usually go down following passage of these laws. Criminals are now worried about robbing a law-abiding armed citizen instead of just an easy target. Accosting a jogger out for a run in Tumon, that's going to require second thought on behalf of the assailant. Another reason to pass Bill 296 is to ensure compliance with the Ninth Circuit Court of Appeals. On February 2014 of this year, the Ninth Circuit Court published a decision in Peruta versus San Diego County. San Diego County was found that their May issue laws for concealed carry, which required showing exceptional cause, were unconstitutional and struck down as illegal. The San Diego Sheriff's Office has since begun to issue concealed permits on a shall issue basis. A little over 30 days later, on March 21st, 2014, a little over 1 week ago, the U.S. Ninth Circuit Court of Appeals released a decision in the case of Baker versus Kealoha, which vacated a lower court decision that upheld Hawaii's restrictive May issue carry permit system and required required the lower court to re-examine the issue in light of the Ninth Circuit's recent Peruta decision. In other words, Hawaii's May issue system is also unconstitutional and will need to be changed into compliance with established law. In light of these decisions, Guam is currently not in compliance, and it's only a matter of time before the law is challenged here as well. Instead of spending money on the defense of a law that we know is not constitutional, we should pass this bill which lays framework for the proper regulation in line with an established and successful system of shall issue for Guam firearms identification cards. I and the members of the Guam Gun Owners Association, whom I represent, are fully in support of Bill 296 and urge you to pass it with little to no delay. We feel the passage of this bill will have a positive impact to the security and safety of our community. By passing this bill into law, the safety and welfare of our island community will be exhibited by this legislative body. Our association includes approximately 1,000 affiliate members who are just as passionate on this bill as everybody at this table. Thank you.
Thank you very much. Mr. Gibbons?
My name is Jason Young, and I would like to testify in support of this bill. Under current Guam law, there is no clear process, transparency, and applications for a concealed weapons permit tend to languish in administrative bureaucracies for weeks or months at a time before you hear anything from the police department. And even if you call, they don't have anything to tell you. So I personally believe that a clear process that's defined by law would be beneficial to both the people of Guam that want to protect themselves with a concealed weapon and to the police department, as it should cut down on their workload for this. You know, it's an application. There's a clear set of criteria. If you meet the criteria, you get issued a permit. Currently, everything goes to one lieutenant who has to review everything. I was able to obtain a concealed weapons permit, which I've talked to a lot of people, and they find that kind of amazing. But I got a call about 6 weeks later, and the officer requested a lot of additional information from me about what I wanted to do, and even included such as what was my income. And I didn't feel that my income made any difference on the right to protect myself. It doesn't matter if I make $100,000 a year or 10. Someone trying to stab me is still someone trying to stab me. And money's not going to protect me from that. Sorry, I had written remarks that I forgot to bring, so I'm going to put them on my phone. But everywhere that we've seen these concealed weapons permits issued on a shall issue basis have crimes decreased statistically. This isn't just us talking anecdotally. This isn't statistics from the NRA. This is statistics from the FBI. And this bill, I think, is considered a win-win for the community. I know not everybody is in support of firearms. We definitely are. I mean, that's why we're here today. But under current law, there's no training requirement. Like Ken said that one of his colleagues, who is a sworn federal officer, was denied a weapons permit, and he's a trained federal officer. I'm a real estate agent. I don't have a military background or a law enforcement background, and I was not asked to provide any information on my competency or use of a firearm, even if I'd done it before. It was like, oh, you have a Guam Firearms ID, you're okay. And it's just kind of staggering that I can get a permit, but a federal officer can't. Now, I'm happy I got one, but I just think the clear process would benefit everyone as a whole, including the police department and civilians alike. Thank you.
Thank you very much, Mr. Young. Sir? Can you? Not a problem. Can you just pull the mic up, turn it on, please, and identify yourself for the record?
I'm Gary Higginbottom.
Thank you,
And
Gary.
I came in support, and I really wasn't prepared with anything written, but I just wanted to give you my background and how I feel about this. I'm in strong support of this. I have been very upset in Guam with the laws, the way that they have been applied. I came here in 2005. And to give you a little background on myself, I'm an ex-Navy ordnance specialist, and I spent 37 years between the Navy and the Department of Defense as a contractor managing a company. I came here and managed naval magazines, ammunition, logistics, came here and applied, and I told them that I had had a federal firearms license in my hometown for 13 years, and that I had carried a concealed weapons permit in Washington State for 20 years, they laughed at me. I was carrying a secret clearance, transferring back and forth with a highly classified work every day. I have gone through 2 civilian police academies, one in Washington, which was 16 weeks long, and we had our own volunteer force that supported the police in our town. We were even allowed to carry weapons by approval of the sheriff and the chief of police if the officer we were riding with shot with us, trusted us. For 4 years, I did ride-alongs with police, was very involved with it. And I did carry my weapon a lot, never had to use it. I've never had to use my weapon. I was trained in the Navy how to do it. I was trained as an expert, but that's a long time ago. I've owned weapons since I was 15 years old. When I was in the mainland and I held my business, I dealt and sold to police, military, law enforcement for exclusively. It was a small town, but a very large county. When I got here, I was insulted by the laws. I was insulted by Hawaii's laws because I came here from Hawaii, and Hawaii's laws were written the same way. You either had to have special permission from somebody you knew or somebody who had some clout, then you could get it. Okay, so I came here. I take objection to the word shall. I agree with this law. I support it. I want it to go through. But whenever you say shall in a technical meaning that I was trained in the military, that still leaves it up to the discretion of somebody. Under our Constitution, if we're a law-abiding citizen and we can prove it, and I have no problem in proving it, and I have no problem giving identification, training, and everything, all my experience. I've gone through training classes in Hawaii. I had to go through safety training classes again. I have no problem with that. But this law should say will issue if you are a legal citizen of the United States and you are a law-abiding citizen. We have the right to protect ourselves. The police cannot protect you. You cannot, even in a small island, expect to be caught in a situation and yell for help and have a policeman get there before you're knocked down or kicked or stabbed. Okay? So I really do I'm insulted by the word shall. For 37 years I dealt with technicalities dealing with explosives. Shall, will, may, they all have very, very specific technical meanings and can be construed in different ways. The Second Amendment does not say shall. It says will not be infringed. And like I said, I strongly support this bill. I want it to go through. I have no problem with all the requirements, and I'll meet them. I'm going to go back through another NRA course here. But I think the island needs to come up to snuff like you're seeing. 41 states have already done it. I carried, like I said, 20 years in Washington State with law enforcement personnel. I was trained with law enforcement personnel. And you come here and you find this shall, and it always comes down to the same way in Hawaii. It's personalities, clout, and only certain people can get by the shall. We have people that are highly trained, highly certified, highly qualified, very experienced, very mature people. They should be able to, protect themselves. So I don't want to be redundant. I'm sorry I didn't come with anything prepared, but this is from the gut. I'm a life member of the NRA. I strongly support concealed carry. I'm applying now for a Florida concealed weapons permit over the states, you're covered under other states' laws. Guam really needs to do this. We're getting to the point, and I just heard recently, a month or so ago, where a Japanese tourist was walked up to and somebody asked for money. He said no. They cold cocked him right in the street down in Aguon, stole his money, and run off. You know, it happens here. And a policeman will not be there to protect you or protect the woman that's protecting herself or her children. If she's qualified and certified, she should be able to get her concealed weapons permit, and it should not be a shall, it should be a will because of the Second Amendment. And that's all I say. If you have any questions or anything, you know.
Thank you very much for your testimony this morning, Mr. Hickenbottom. Mr. Wilson?
Yeah, my name is Stanley Wilson. I did present some written testimony.
Yes.
I don't know if you all have it. I'm going to kind of walk through it and at the same time elaborate on a few of the issues that I put in my comments. I'd like to add my comments on Bill 296 that would change Guam's concealed carry law from one of may issue to shall issue. I am a 40-year resident of Guam, a certified public accountant in private practice. I am the Secretary and Treasurer of the Guam Sports Shooting Federation, GSSF, a gun owner, and the holder of a valid concealed carry permit. I'm also an NRA member and a member of the Guam Gun Owners Club. I am strongly in favor of the legislation that would change Guam's current may issue into shall issue. I speak as a gun owner, a voter, and on behalf of the GSSF. The current system in place has two major defects as I see it. First, it places the decision in the hands of a single person who has the possibility to issue permits to individuals who may not have sufficient training or may not have or may have enough political influence to have the chief of police, who is a political appointee, to issue permits simply because of their political power. And I hope the chief doesn't take exception. He authorized mine, but the thing is that it kind of puts the chief in a bad position, the current system. It's his kind of decision, and he has kind of poor guidelines now. My understanding, and he can nod his head, but the chief of police is sort of requiring training or strongly encouraging it? No. So I would think that the chief would like to see in place specific guidelines like this law provides for training, criminal record, sanity, in other words. And so the second major problem is that there are no guidelines to ensure that the permits that are issued now are issued only to individuals with criminal-free backgrounds and a level of training that makes them understand the duties and responsibility of concealed carry. Bill 296 puts in place guidelines regarding the applicant's background and training. Further, it would put into compliance with current court decisions as they relate to constitutional right to bear arms, as other people have indicated. As part of the process that I went through to obtain my concealed carry permit, I took 2 classes on gun safety. One course was on general gun safety and another focused on concealed carry. When I decided to take these classes, I figured that being a longtime gun owner and an active sports shooting competitor, I assumed that I had little to learn from the classes. Not true. Not true at all. The classes, which took 2 full days to complete, gave me additional knowledge and experience to be a safer and better informed gun owner. While I do not favor the requirement of classes to simply own a gun, simply because of constitutional issues, the classes should be required for concealed carry, and currently they're not. Now, this fixes what I see as a problem. Guam has changed a lot since my arrival 40 years ago. I lived in Malolo, and when I first arrived on Guam, I did not lock my doors, and when I went to work, and again, you have to work for the day, I did not lock my doors then because it did not seem to be required, and even more importantly, I didn't even have a key. I literally didn't have a key to my house. Times have changed, and things are different here. Some certainly for the better, some certainly not. I believe that if more qualified and trained individual had concealed carry permits, it would have the effect to lower crime on Guam, as I think other people have indicated that it does in other jurisdictions. individuals are not sure of who might have the ability for self-defense. They would be more likely to think things over before they acted in a criminal way. It makes good sense. I hope that this body will act favorably on Bill 296 and change Guam laws from a may issue to a shall issue jurisdiction. I think, constitutionally, blah, blah, blah. What this thing does is it puts in place a structure so that the chief of police has a process to say, yeah, this person is qualified. Criminal record is clean. He has no history of mental health issues. He's had sufficient training, and he has a legal permit to own a gun already. Guam already has probably some of the most stringent gun ownership rules and regulation in the United States. That man over there can go look up in his records and find out not just that I own guns, but he can find out how many guns I own, what type of guns they are, what their serial numbers are. That's not the case in most other jurisdictions. States don't maintain records of individuals' gun ownership. We do. I don't have a problem with that. The problem of crime on Guam isn't a problem of registered legal gun owners having guns. The problem is criminals having guns. That's always sort of the national problem. The people at this table that all have guns and are registered, and several of us have concealed carry permits, we're not the problem. But if more people had concealed carry permits, I think it would, in fact, lower crime. So I am in favor of the bill, and I thank you for your time.
Thank you very much, Mr. Wilson, for your testimony this morning.
I prepared something in writing, but these fine gentlemen have covered all of the points in my writing. So
I'm sorry if you can
I have some feelings that have
Sir,
come up.
I'm sorry if you can just identify yourself for the record.
Sure, my name is Brian Scheibel.
Yeah, thank you, Brian.
My local family names are Esteban Blas, Sogui, and Delgado. So I have a few feelings about the matter. One thing is that Guam is family. That we are all pretty closely associated with each other. We see each other on a daily basis, and we have a responsibility to each other to maintain that sense of family and community. And one of the things that I think is important with that is that we foster a sense of trust between each other in the community, and that we are willing to have a sense of trust amongst our fellow law-abiding citizens. That to be a law-abiding citizen is an active choice in society, and it certainly is not the easy choice, and that all of us work constantly on a daily basis to represent the law. So one of the instances that comes to mind is the Chad DeSoto incident that happened in Tumon. He was violent, he was quick, and he harmed a lot of people, and he killed some people very quickly. And in that situation, I would not have the ability to defend myself. There's two reasons. One is most likely I would not be carrying a firearm in that situation, because the open carry regulations on Guam are not very effective. It's not a popular thing to carry a firearm openly in the community. Okay, one of the reasons is because the level of education on firearms in our community is not as strong as it could be. Now, we have excellent firearms training on Guam. We have a United States Marine Corps active duty National Rifle Association firearms instructor on Guam, and he intends to be here for the duration of his life. And he takes his job very seriously. And I have obtained 3 separate individual trainings in firearms on Guam, and there's a 4th training that's being offered soon. So we have the ability to take these trainings, and they're expensive. They're several $100s a piece, and you have to bring your own ammunition, which is another couple $100s. So
So we put a tremendous effort into making sure that we're appropriately trained and armed, and it's a personal obligation for us. Another thing that I find is really important to the issue is we have senior citizens, we have disabled people, we have women in society who are not always equally able to protect themselves. And in our current situation, those people, senior citizens, women, and disabled people, aren't armed in Guam. There's not a high level of armament with those people. And one of the reasons is because our concealed carry law is so limiting. And if we open that up and require the training, not only will that allow them to be more educated about the policies and procedures and requirements, but it will empower them to protect themselves and their families. I think that's perhaps all I have to say at this time, but thank you.
Thank you very much, Mr. Sherbo. If I can ask Senator Tony Ada, if you have any questions or comments initially?
Nothing, Mr. Chair. I'd just like to thank the gentleman for coming up to provide your testimony. Thank you very much.
Thank you very much, Senator Ada. Senator Duenas?
Thank you, Mr. Chairman. I have a question. I'm sorry, I forgot your name, the gentleman. Kenny. Yeah, as the testimony was being discussed earlier by the immediate retiring speaker, it was brought to my attention by some folks that I know very well, too, that are highly trained in the use of firearms and the like, and understand this issue greatly. One of the reasons this gentleman expressed the need for this type of legislation is because of there are individuals actually that if they're forced to carry while being licensed, exposed carry, sometimes that's a greater threat to the community, because if you had some criminally minded individuals, just seeing that weapon available becomes a bigger problem to access that weapon, because it's in a holster or whatever else, or displayed, and you don't know who's around you a lot of times. So the concealed permit by a person who's eligible to carry is actually a safer situation for the community than a person who would be going around with a holster and a sidearm that you don't know who the other guys are around you that could obtain your weapon easily. Is that an observation that you share?
Senator Duenas, yes, it is. That's absolutely correct. Speaking from, hypothetically, a criminal mindset, if I was a hardened criminal intent on committing a crime, and I walk into a location to commit that crime, and I see somebody with a firearm openly presented in a holster, believe me, I'm going for him first. Because he's a threat, one. Two, that's another weapon I can use. Speaking from a criminal mindset. So having a law-abiding citizen legally licensed to carry concealed makes it a safer environment.
Thank you very much, Senator Duenas. To the gentlemen that were here initially, I know Senator Tom Ada wanted to pose a general question, so this would be also inclusive of yourselves. If you would like to respond, I would like to invite you back to the table. Senator Ada?
Thank you very much. First of all, I think a lot of the testimony that was given this morning was very, very well presented. I presume that organizations such as yours and maybe members of the NRA probably had some input in formulating this bill. Is that correct?
Yes, it is, sir.
Okay. I just have some questions about. I know that during the testimony here, somebody had mentioned the word about a person who has had a history of certain crimes would not be eligible to get a concealed license permit. But in the bill, it seems that there's this magical 3 years. If you've been beat up your wife in the past 3 years, then you're okay to get it. But if you have had a record of that, and for example, family violence is not a felony
incidences is just a misdemeanor. So, you know, the guy who beat his wife 1, 2 times, the tendency is there probably, but can still be eligible for that. So I'm just kind of, even if I guess if you've been charged with a DUI before, again, there's that magical 3 or 5 years, or I guess after that period, you're clean. So I have a concern about that. I have a concern about the fact that I'm glad that the bill requires that the individual who receives a permit is going to have to undergo training and produce some kind of evidence, either from the NRA or from whoever is allowed to provide training. But the bill doesn't seem to provide a currency. You know, it just says, I may have had an NRA training certificate from 10 years ago, and the way I read the bill is that that's good enough. And I think that's even further evidenced by the fact that as a veteran, if I can show my DD-214 and shows that I have honorable discharge, you know, I can qualify for all that, but I haven't touched a weapon in decades. I wouldn't consider myself qualified. I would have to undergo training. So I'm concerned about, you know, how stringent we are with the training requirements. Regarding the training, you know, when the Castle Doctrine bill first came out, I really had the idea that, boy, people are going to run out and start buying guns, and I'm afraid that if we don't require training to go with that, we may run into problems. And I was visited by a reputable member from the local organizations, and basically discouraged me from, you know, it's already going to be expensive enough to own a weapon. Now to require them to undergo this training is just, you know, it's a requirement that really we should not have to manage. So I'm just kind of concerned about why is it a bad idea to require it for those who are running out to implement the Castle Doctrine and be able to protect themselves, but require it here. And finally, just the one thing that kind of jumped out at me is that one of the criteria is that the individuals applying for a license must be a resident of Guam and a U.S. citizen. Well, then that kind of segments the community, and if you're not a U.S. citizen, then I can't, you know, I could be living here 30 years, but by virtue of some compact agreement, I can never be a U.S. citizen, so that means I can never carry a concealed weapon, so I'm concerned about that. Finally, I just want to state my position that I do support the bill, provided that we kind of adjust some of the concerns that I've raised. But I also ask that the advocates for this sort of bill, that they probably really need to refrain from sending, you know, emails to senators with some veiled threats. And you know, it's emails like that. Maybe I'll go out and get my own. I'll get my own concealed weapon too. But I don't think that really helps the cause. And I'm not looking at you, but I didn't get. I'll say right now, I did not get the email from you. But that really does not help the cause at all. And I hope that those who are doing it, and you know who you are, that you stop that sort of thing, because it does not help the cause. Okay? So I've stated my concerns. Maybe if you can just kind of educate me more then on maybe why these concerns are unfounded.
It is my understanding that federal law dictates that family violence, convicted of family violence, are not allowed to own a firearm, period. And Guam follows that. Guam law also indicates that in order to get a permit to have a gun, not even just to own a gun, not a concealed carry permit, you must be a U.S. citizen. So that's in Guam law. So I don't know which would trump it, but the fact that citizenship is already required, this law doesn't really affect it. You know, obviously you could change it to change the law to make it long-time permanent residents be allowed to own guns on Guam, which I believe they are in the U.S., but just not on Guam.
Okay, so it's not clear in the bill then, because the way
Well,
the bill
it's
reads.
clear in the bill that they have to be a citizen.
Correct.
It's also clear in the existing legislation regarding getting a firearms ID card that you be a citizen.
Okay.
You'd have to change the law in general, correct, or another portion of the code or whatever. I understand, and I almost agree with your worry about training being current. And I wouldn't have a problem with the law being amended to clarify that when we're talking about training for as defined in this legislation, that it be relatively current and maybe even renewed over once every 10 years or something. Maybe not every single time you reapply for a renewal, but currency certainly wouldn't be harmful, I don't think. And you said about you made a comment about people, Castle Doctrine, people rushing out to buy guns. Well, I don't think you really have to worry about that, because I've been trying to buy a particular gun for over 8 months now, and I'm dealing with the Smith & Wesson distributor for the island of Guam and Micronesia, and for the last 8 months he has not been able to acquire that revolver for me. Guns are not readily available, period. If you go to Moylan's, which is a FFL holder, they don't have any inventory. Karada up in Dedido has very little guns that have lots of dust on them. They've been around for a long time. That's not really going to be an issue, I don't think, because this doesn't encourage people to run out and buy guns, because you can't buy them anyhow for all practical purposes. It's very difficult to acquire. I don't know if I missed anything that you indicated, but family violence is covered under federal law, which would also, and you go ahead.
Yeah, the one point was in the bill throughout. There's if you've been clean for the last 3 years from DUI charge, family violence charge, you're okay. Versus in some of the testimonies, there was if you've had a history of family violence, then that kind of disqualifies you. So it's a question of history versus in the past 3 years.
I'm not a lawyer. I don't know how to read the bill. I don't know how to address that. I think somebody does here.
Senator, my name is Rory Tenorio. I'm a retired Army officer. I'd like to make some comment in regards to your questions. First, officer, it is predicated upon your ability to own a firearm legally to begin with. Issuance of a concealed carry permit would not occur unless you are already eligible. So we need to put it in that context. This is part of a process, which is really what we're trying to do here, is clarify an existing process. If you're not eligible to own a firearm to begin with, it doesn't matter if it's 3 months, 3 weeks, 3 years, whatever. You have to be eligible to own a firearm to begin with to apply for the secondary part of that process, which is a concealed carry permit. So that should alleviate that concern. I know this legislation is also predicated upon that the first parts of the process have to be met, the criteria has to be met before any of this would take place to begin with. So we need to put it back into that context. Your concerns about people running out to buy weapons. Again, that may not be a true concern. That's a perception that basically is kind of invalid. If an individual cannot afford a firearm now, it's not going to change if this changes. Now, when I say an individual, I'm referring to a law-abiding individual, someone that follows our established laws of our territory, our country, and our nation. If you're a law-abiding citizen, which majority of the people here are that have this concern, we're going to follow the laws. We're going to go through the proper societal and judicial processes involved to own a firearm as guaranteed by our constitutional right. The problem, as Mr. Wilson stated, is a criminal element. They do not adhere to any of those laws. They do not adhere to our societal or our moral codes like the majority of the people that elect our elected officials. That's a judicial and a legislative process that we all follow because we abide by our laws. You stated another concern. Now I'm having a senior moment. Training. I don't mean to make this personal. In my military career, I was, you may remember, you were in the reserves at the time, sir, Guam Territorial Command, which is now called Garang Element. Our command has changed. I was the marksmanship coordinator, program manager for over 5 years. I ran the program to train our soldiers in how to, for competition, Winston P. Wilson. I managed the money, I managed the training, I did the actual training. I had to qualify expert on every weapon in our inventory that we used in our competition. I'm a certified weaponeers trainer. I've been a competitor, not only in the military, but also in the Army. My weaponeers certification, my Army certifications, those may be years ago, but there's one thing that never changes: the knowledge. Once I gain that knowledge can never be taken away from me. It never changes. You, sir, you mentioned you haven't touched a weapon in how many years? Your military career, though, you handled that weapon for over 20 years, even if it was only the annual qualifications at a minimum. Senator Aguon, same thing. Most recently, his tour in Afghanistan, my tour in Afghanistan. That's knowledge that we will have for the rest of our lives. How current is it? Yeah, we may get a little rusty, but the basics of responsible firearms handling never disappears. It never disappears, especially for those of us that are in the military, because it is so ingrained. It's so ingrained. So that should alleviate some of your concern there. General population, non-veteran individuals, yes, it's part of responsible firearms ownership, that you become familiar with the weapon, you make the time to learn it, you set aside the money to purchase the ammo so that you can go practice with that firearm so that you can responsibly handle it. That's all part of the responsibility of a individual, whether they be a law-abiding citizen, military veteran, whatever. So some of your concerns, sir, I just want you to take it out of that perception stage and actually try to put it back into perspective and make it more relevant. So hopefully I've stated some things that have helped adjust your perceptions on it. I thank you for the time. I didn't intend to get into this, but again, I thank you for your time.
Thank you, Mr. Tenoyo.
I
Yes,
have
Mr.
one
Wilson.
more comment that was brought to my attention regarding the currency of training. I'm sure that you, just like me, last time I renewed my driver's license, we finished that driving class all over again and took a test, a written test. Your training in getting a driver's license is enhanced in my case, the 56 years I've had a driver's license, every time I get into a car. And the same thing kind of with scuba diving. I'm an avid scuba diver, 2,000 dives. I go through a mental process every time I jump in the water. What would I do now if this happened? What would I do then if this happened? What if my buddy was out? I mean, I go through this process to be really on top of and aware of what I'm doing. I own a bunch of guns. I shoot often. Every time I touch one, I go through the process of, is it loaded? Is it unloaded? Is it really unloaded? Oh, well, let's see if it's. Every time I handle a firearm, I think about my training, my knowledge, my skill set. So while I don't particularly have an issue with having training current, and then renewed from time to time, I'm not sure it's really necessary. Just like when you get into a car, when I go scuba diving or when I handle a gun, the training comes back. It's with you. It stays with you, and actually is enhanced every time you participate in that activity. Thank you.
Thank you, Mr. Wilson. Mr. Gibbons?
Yes. Actually, I just wanted to expand on that a little bit. 22 years in the Air Force. I started firing firearms when I was 5. When I started to learn how to fire 22s. 22 years in the Air Force, fired expert 18 times. I'm never going to forget how to do that. Retired from the Air Force in '88. I go to the range probably once every 2 months or so. To say that I have to have recurring training, to just like you said, to continue something that I've been doing for 60 years, and in 60 years I've never had a misfire. I've never had a gun go off accidentally when cleaning or breaking down or whatever. You know, making sure your gun's cleared, making sure it's empty, whatever. These are all inherent things that you just, they're there. You never forget it. So, yeah, I'm taking a little bit of exception that, have to have recurring training. Thank you.
Thank you, Mr. Gibbons. Gentlemen, thank you very much for your testimony. Speaker Pangilinan? Or Senator Addett first to close off?
I just wanna commend the panel for the testimony that you gave. I think you did a good job in promoting the bill to move it forward. And if I was a little off mark, I think I probably have a better focus now on the bill itself. I thank you very much for that.
Thank you, Senator Addett. Gentlemen, please, if you could just stand by for a second. Speaker Pangilinan?
Thank you very much. Forgive my ignorance, I guess, on this issue, but when you say concealed arm permits, it's a loaded concealed arm permits?
There's no reason to have it unloaded.
That's what I thought. So it's ready to fire.
And out of courtesy to this committee, and because I'm not sure what your rules are.
You left your gun at home, right?
Yeah.
Thank you.
It's not on my person at the moment.
Yes, it's not supposed to be when you enter the legislative buildings.
Actually, I made a phone call this morning to find out.
Oh.
Follow the rules.
Yes.
Go ahead. That's right.
Actually, Senator, in reference to your question, depending on the type of firearm, whether it be a revolver and or a pistol, you can carry a pistol in a what they call certain levels of condition of safety, where it is not ready to fire, even though you're carrying it. You have to, one, chamber around to prepare it to fire, or you can carry it with an empty chamber. Okay. Whereas a revolver's a different story. If you have all the cylinders filled with ammunition, then yes, you are ready to go. But most people practice the safety feature of they carry the weapon with one chamber, one of the revolver chambers empty, and a hammer on it. So you have to actually cycle it to make it ready to fire. So again, that is a nature of your knowledge and your safety protocols that you've learned and that you practice. So again, a perception is it's ready to go, not necessarily.
And the difference between a revolver is a revolver has a revolving chamber.
It has a revolving
and a
chamber.
pistol has a magazine.
Has a magazine fit.
Okay.
But the thing is they can both be rendered safe by not having a round in the chamber ready to go.
Okay. I just want to know what not to buy or what to buy.
Again, sir, it's immaterial which one you buy. What is important, though, is that you make the time and you put aside the money to buy the ammunition so that you can go and learn that weapon, understand it, become familiar with it, and be able to handle it responsibly. That's the key.
And I'm saying that even though I've had people burglarize my home while I'm in my home over 3 times in the last 18 months, maybe 12 months. And we haven't caught a single one yet. So I didn't know about Phil saying that guy that they catch has committed 20 burglaries. 3 of those are mine.
Well, Senator, you have been very fortunate that you've gone through that 3 times and
I'm
you
fortunate
have survived it.
I didn't have a gun he could take and use against me. I'm fortunate he didn't have a gun coming in. Well, I don't know if he did because I never caught him. But it's been fortune and luck and a lot of prayers, I guess, that go. But one of the things, that I just want to kind of also to take a look at when I understand the training and I understand that the only people in this room that own guns are responsible gun owners. We don't have any criminals coming here to testify on this bill. So everyone that's testifying here and present is probably, I would give them the benefit of the doubt and presume that they are all responsible gun owners. They want to see that gun ownership, carries responsibility, and they want to assure the community and this body that this is something good because of the requirement for responsible ownership. The philosophy of owning guns is a completely separate debate, I think, in terms of, what it does and so forth. But I do want to say that even though we have responsible gun owners, on the issue of currency of the training and reminding of, the process, the checklist that you go through, we've had police officers cleaning their guns and they go off. They handle it every day. They qualify. I don't know how often they have to qualify, but accidents do occur, and repetition is the key to learning. So maybe the currency of the training, as San says, could be something to be considered. Just because, even though the knowledge never disappears, the proficiency may do so without working with it and handling it on a consistent and regular basis. And that's where I think maybe this issue of, some kind of currency or recentness of the training program may be beneficial to enhance responsibility in the gun ownership. So that's just my perspective on that. I've read stories where, tragic accident. Young boy takes his dad's gun, police officer, goes out, shoots his neighbor. And again, there's nobody that should be more of a responsible gun owner than a police officer, because it's a matter of life and death for him for ownership of that gun and the safety of the community. But those kind of things occur, so again, maybe some kind of continued, and maybe those are just tragic accidents that, accidents always could be avoided with training, and maybe that's where this issue can be looked at a little bit more carefully, as Stan has mentioned, and as the individuals have mentioned, that, so you are doing that on your own because of your desire to ensure that not only are you safe, but your family's safe when you have a weapon in the house or available to be accessed in some fashion. So I just want to thank, again, the panel. I think it's very informative for me, who is not as familiar with many of our community members on guns and their ownership and responsibilities associated with those ownerships. So I thank you for some very informative testimonies.
I'd also like to add just one thing. I indicated that I took 2 NRA classes locally and recently. The first one was on sort of general gun safety. The second one basically was focused on concealed carry by a NRA licensed instructor following NRA course guidelines and materials. It focused a lot. It focused to some extent on the local law. It had we learned a little bit about Guam law as it relates to gun ownership and carrying. But it also focused an awful lot on the duties and responsibilities, and that if there's any option to walk away, to get away, and that you're not a policeman, you're not a police officer, but it's really the last resort. And that class was useful to me. It really was, in anticipation of getting my concealed carry permit. It really makes you think about the fact that when I leave my home and I put my gun underneath my shirt and walk out of the house, I think about the fact that, this is not something, it's not a toy, it's not, it's not that I can be macho now, I can, tell that guy that, we'll go to hell too, It's not that at all, it's the last resort. And so that it's conceivable to me, again, and I'm going against what some of my fellow gun owners are saying, is that somehow or another, if maybe the law would be tweaked a bit to say that a law in focusing on concealed carry should be part of your background. And whether it's last month or 10 years ago, that doesn't leave you. You know, I mean, it really doesn't, any more than the driving classes we took when we were teenagers to learn how to drive mom's car. You know, I mean, that sticks with you, you know, and so that I did want to indicate, though, that one class that I did take was very useful as a concealed carry permit holder.
Senator, just a couple of things. You mentioned that in your own personal experience that you were fortunate that you didn't have a weapon that they could take to use against you. I don't want to make light of a situation, but we have many cases, most recently Miss Nancy Moffness, God forbid, where it wasn't a firearm that was used against her. It was the pipe that she was using to defend herself. So again, we don't want to generalize and attribute that only to firearms. Within our homes, we have many instruments that can be used to defend ourselves. Brass lamps, kitchen utensils. But more importantly, it's our mind. We have to use our minds to defend ourselves, and that is inherent in our genetic makeup to survive, whatever it will take. As a service member, having been in combat zone, maybe my thought process is influenced by that. But again, it's immaterial. Anything can be used as a weapon to defend yourself, and that's kind of what we're looking at. The mention about the currency of training, again, I don't have a problem, but again, we need to go back to this is part of a process. We're just trying to refine an existing process. We're not trying to take anything away. We're actually trying to make it better. We're trying to keep from stumbling over our own feet in regards to this process. The one thing we need to be careful of when we start talking about required training is eventually we have to be careful that that does not incur an additional cost to the government to ensure that that training is done. If there's no private sector to do that, then it becomes a responsibility of government of Guam, i.e. GPD, to provide that training because it's a requirement by law. So we want to make sure that we do not incur additional costs to our taxpayers by legislating a new law that's duplicitous in nature and really not necessary. We're just creating more problems for ourselves. So I have a little concern about the making it a required training in that regard.
Yeah, I understand, and I thank you for that. And I also have I said I didn't want to debate the issue of gun ownership and non-gun ownership, but you're kind of driving me into that direction, you know, because when you look at it and the way you describe owning guns, it's expensive. So the average citizen may not be able to afford, you know, a gun, a concealed weapon, in order to defend themselves, even if he wants to. And it's only reserved for those with better economic means. Again, you know, I don't want to argue that, but the way you're presenting those arguments, those are things already creeping in my mind that shouldn't be there based on this bill, is what I'm trying to say. But so that's why I want to say I thank you for the focus on what this bill will do, what the current law allows and doesn't allow, what the current law covers and doesn't cover, and how this may just enhance the current law with regards to improving gun safety and gun ownership in the community under a concealed weapons permit. So I thank you for that kind of input.
Thank you, Speaker Pangilinan. Do me a favor, Mr. Young, if I can just ask Senator Morrison to pose this question first, and then if you would like to comment. Senator Morrison?
Yeah, thank you, Mr. Chair. I just wanted to touch upon the 41 states that you say have similar arrangements and guidelines. Do those states have reciprocity agreements, or if you had all these in line, you can actually go to another state? I know the gentleman also mentioned he's applying for a permit through Florida via the internet. So is there when I read this here, by a Guam certified or National Rifle Association certified firearms instructor, so if they had at least that in place, would that also qualify from state to state, or something work?
Many states do have reciprocity amongst themselves, but to gain reciprocity for Guam within the 50 or within CONUS or where not, that is something that would probably have to be adjudicated between the attorney generals of each territory and state. But yes, many states do offer reciprocity for concealed carry permit holders. Like if I had a concealed carry permit from Florida, that would be recognized in Georgia, Washington, or whatnot. So yes, there is reciprocity amongst states.
So the president of GSSF just returned from Florida for a shooting match 2 days ago. And he indicated to me on the phone yesterday that his concealed carry permit for Guam is valid in Florida. So Florida does recognize it.
But those arrangements are made through, like you stated, the Attorney General's office. State to state. Okay. Thank you, Mr. Chair.
Thank you, Senator Morrison. Mr. Young, I understand you had a comment you wanted to add.
Just as generally to add to this, I just wanted to say a few months back I was in Tumon. It was a Friday or Saturday, and I don't remember exactly, but I've been drinking, so I did not carry my firearm. I leave that at home when I go out. Now, like I said, I was down in Tumon, and a group of guys just drove into where we were at, and hopped out of their car and just started yelling at people and drew people walking on the street. Near the bar we were at had a deck, just started drawing people into fight and attacking people randomly. I got beat up. A couple of my friends got beat up. I mean, it was not a great night for us. But we were sitting there, and like I said, this wasn't just people that were in the bar that got accosted. This was people walking along the street randomly. And one of these people pulled a knife, and before this fight had even started, when they were just yelling, we had already called the police. And this bar is 100 yards from a police station. 100 yards. I mean, it's literally down the road. I could hit it with a golf ball. And we called the police. Fight ensued. Someone had pulled a knife. They didn't stab anybody at this altercation, but they went to the immediate bar next door and stabbed an active duty service member. I mean, it was in the news. We all talked about this. But it's like it goes back to what we were saying, is the police can't be there all the time. Even when the police are very, very close, they still can't be there all the time. And it worries me a little bit. I was involved in this situation. I did not arm myself because I wasn't in the proper state of mind to be bearing a firearm. But in that situation, I could have just as easily been walking on the street, as I often do in Tumon at that time, and that guy could have stabbed me. He went and stabbed somebody else, and the police had already been called. So it's just, one of those things, just the onus to protect yourself is important, and it's not just with firearms. We saw the jogger that was attacked just 2 weeks ago now. It's not just about firearms, it's about having the common sense to protect yourself. He should have dropped his wallet and ran the other way, but instead he was very trusting and he tried to talk to the guys. He was right across the street from a store he could have run into, or a church, or a school. So when we talk about protecting yourselves, we obviously advocate very hard on the side of firearms and concealed weapons, but our group, a lot of other groups, also you just advocate for general self-awareness to protect yourself. A firearm is not the only means, but it is a very important one, and in concert with that, we are very interested in that, also are interested in other means to protect ourselves and promote that, whereas we don't see it a lot with other people. It's like, well, we'll just go after the criminals later. And I just wanted to share that.
Thank you very much, Mr. Young. And gentlemen, thank you for your testimony this morning. We're going to proceed. We do have a few other individuals that would like to provide testimony for this particular legislation. On Bill number 296, if I can invite Mr. Fred Berdalio, Guam Police Department, Scott Shelder, Deputy Chief Attorney General Phil Tydinko, Darrell Becuse, Greg Massey, and Diane Botchler. And Henry Raffan. Please excuse me if by any chance I mistakenly mispronounce your name. Fred Berdalio, Scott Batchelor, Phil Tydinko, Darrell Becuse, Greg Massey, Diane Botchler, and Henry Raffan. Chief, if you can open up the discussion, please identify yourself for the record and proceed.
My name is Fred Berdalio. I'm the Chief of Police for the Guam Police Department. And I want to go ahead and just read my testimony here for Bill 296-32. Good morning, Senator Frank Aguon, Senator Tom Matter, Senator Ben Pangilinan, Senator Tommy Morrison, Senator Chris Joannis, Senator Brent McCready, and Senator Tony Etta. Dear Senator Aguon, members of the committee, buenas and hafade. The Guam Police Department has reviewed and supports the intent of Bill number 296-32, an act to amend Section 60109 and add a new Section 60109.1 to Chapter 60, Title 10 Guam Code Annotated, GCA, relative to concealed firearms licensing. The Guam Police Department's support is primarily based on the position that the current language of the concealed firearms provision may be judiciously challenged by individuals and organizations of the community who advocate their rights to bear arms, and that their claims that changes to the current language is necessary to be consistent with the Second Amendment of the Constitution of the United States. However, the Guam Police Department recommends that certain provisions of this legislation be modified for the purpose of effectively reducing firearm safety violations. Furthermore, several GPD command staff proposed some following amendments and recommendations for your consideration. Concealed firearms license shall be valid for a period of 3 years to coincide with the current non-concealed firearms and concealed firearms license. Penalties for the violations of this act shall coincide with the initial cost as stipulated in the current fee schedule to process a concealed firearms license. A repeat violation within the period of validity of the concealed firearms license shall constitute the revocation of license for a period not to exceed 3 years. The holder, the second recommendations and consideration from some of the command staff is the holder of a concealed firearms license is formally charged with a crime punishable by imprisonment exceeding 1 year shall have his or her license revoked pending the adjudication process in the event of a court conviction. The license shall be revoked permanently. And other recommendations, a person is ineligible for a concealed firearms license who is undergoing civil and or criminal proceedings with respect to the Uniform Controlled Substance Act, Safe Streets Act, and criminal offenses involving theft, injury, or death. A person is and the other recommendations, a person is ineligible for a concealed firearms license who has been dishonorably discharged from the United States military. And then the last consideration is firearms training and safety courses shall include firearms handling, safety, and proficiency. Your consideration of proposed amendments will enhance some accountability and control mechanisms in the best interest of our community. We thank you for giving us the opportunity to provide our comments on this bill.
Thank you very much, Chief Bradley. Please, if you can identify yourself for the record and proceed with your testimony.
Hello, Senators. My name is Daryl Beers. Unlike everybody else here, they have their military background. They have much more experience than me. I'm relatively new to the firearms community. I am a certified gunsmith. I did work with the firearms manufacturer for a little while. While working for them, we did have to go through intensive manipulation of the firearm, making sure everything was safe, not only for us, but for the customers. We had quite a few people come in encouraging concealed carry above open carry because of the fact that it makes you a target. Everything that I thought about saying, it was already said. So all I can really say is the reason why I believe Guam needs to change their policy. There are a lot of people who do own firearms who are not able, even though they own firearms, they're not able to protect themselves because they're unable to carry. They refuse to open carry. They know that being, that open carry makes you a target. Unless, of course, if you're a business owner, carrying in your business and stuff like that, I suppose that's all right. But as far as the normal everyday citizen, people freak out when they see a gun. It pulls GPD resources and stuff like that for them to respond to something like that when it's lawful to begin with. Guess that's all I really have to say.
Thank you. We're going to go down to the left there, Mr. Massey.
Good morning, Senators. I had to take lunch early because I'm representing not the department as I normally would in front of this body, but as a private citizen. just had a couple, and actually I came down and thought I was going to be one of the only people, and the room was full. So all the stuff I was going to say got said already, just like a lot of the speakers, but I did have a couple, I guess, possible amendments for you folks to consider. I did notice that on the page 7 of the bill, it exempts correctional officers, law enforcement officers, probation officers from the required fees. I'd like to suggest maybe that also adding in regulatory law enforcement officers like myself. Again, I'm not representing the department today, but in my private life, I am sometimes concerned about my safety because of my job for the government of Guam. Okay, as a investigator for the government in a regulatory field, and I'm sure people maybe at public health, I'm at labor, but people at public health and other places that affect businesses, we get into human trafficking issues, we get into basically pointing the finger at people that get arrested for immigration violations and things like that. Once you become really effective at that job, unlike I guess a peace officer, you don't have that firearm when you go home. With me, again, it's I would like to be able to protect myself, and because maybe some of the reason why I need to do that is because of my job. So I would, just like to suggest maybe adding in regulatory law enforcement official, maybe, or regulatory law enforcement employee into that list of people exempt from the fees. The other thing that I had was I heard a lot of about training, and I heard this one person say before that with the old law, those with the money, I don't know where that came from, but those with the money were the ones that could get the permit. It seems to be the case also right now, because if the training, I heard one guy say that you have to get ammo and it costs hundreds of dollars to get this training. I think that's going to put a lot of people, regular people like me, I consider myself a regular person who works paycheck to paycheck, and I'm, as much as I need that the permit, if I'm going to have to go and spend $600 plus on top of that the cost of the gun, and then ammunition's expensive, and I'm going to have to do that constantly, I'm not going to get the permit, just like I don't have it right now. So that was just something to consider on the training aspect. I don't know if you guys want to cap the cost of training, or maybe make some type of training available through government sources. I don't know. It's just something to think about for the person who doesn't have 5 or 10 guns, or who doesn't have a business, and who wants to be able to protect themselves. And that's all I have. Thank you for your time.
Thank you very much for your testimony this morning. Mr. Tadinko?
Good morning again, Chairman Aguon and Honorable Senators. Phil Tadinko on behalf of Attorney General Leonardo Rapadas and Office of Attorney General. Also, as part of full disclosure, Attorney General Rapadas is also an NRA member, so I wanted to just disclose that. However, we support the concept of the bill providing consistency in the law for people to, when they apply for certain licenses, there should be some objectivity to it, because the current statute allows for subjective decision making. Curiously, though, the bill proposes, it still keeps the exceptional cause allowance, yet it does not require any of the requirements that you would under subsection B. So you could still request, and the chief could give it to you without having to, the way I read this bill, and unless there's another lawyer in here who wish to dispute that, the way I read the bill, the chief could still give it to me, and I wouldn't have to undergo any of the requirements that are listed in subsection B. So I point that out. If you want to reconcile that or keep it, that's fine. It seems to me that if the whole purpose is to have these background requirements and training requirements and safety requirements, to put some objectivity on it and make sure that whoever receives a concealed license. I have a concealed license, but I'm not required to undergo any of that training. So it would seem to me that you'd want to be consistent and require that for subsection A, even if they have an exceptional cause, or just take it out, whatever. So I'm just pointing the legal analysis of this bill points up. The Attorney General and our department also believes that the statute should still require, as part of the reapplication process, an automatic background check. The background check only appears to occur when your license has expired, the way I've read the statute. So I'm not talking about training, because I heard that whole discussion. That's not where we're coming from, because obviously it makes sense. If you've had the basic training or the required training, you may not necessarily need it for maintaining for renewing your license. But certainly, how are we to find out when you're renewing without conducting a background check, whether you've been incapacitated mentally, or you have a suspended sentence for substance abuse charge, or you've committed a crime, or any of those factors that would disqualify you from renewing your concealed firearms weapon license. And wherever it references the Criminal Justice Standards Training Commission, I believe it's called POST. So we should make that consistent, because there's no such commission. It's referred to as the POST Commission, if I recall correctly. And all the references to the fees, I think a good suggestion would be to put language there that lets GPD develop those fees, because I noticed you put fees in here, and it seems like guesswork to me. It seems that GPD has been promulgating fees pursuant to the AAA, and you could put that language in there. So it gives it flexibility. I mean, this becomes law. 5 years from now, is it still going to be $15? I mean, we'd have to go back and pass another law to try to meet the administrative cost of that. So I would suggest that perhaps we put language that offers GPD the flexibility to adjust fees pursuant to the AAA process. Wherever there's a reference to, this is the fees. Because once you put the fees in there, it's like, that's like carved in stone until we pass another law to change. And I don't see any reference about renewing or changing these fees pursuant to the AAA. So I think there should be some flexibility there. And I wasn't quite sure if this was going to be consistent with some of the other statutes. I haven't vetted against, like, for example, the private security, armed security training law that's out there, and whether those folks trained under that would automatically be also eligible, or at least meet the training requirement. And I think they would for applying for a concealed weapon. And I believe, too, that, like on page 9, the requiring GPD to mail out written notices to remind people that your license is expired. Heck, DR, Revenue and Tax, doesn't even do that anymore because it costs too much money and time, and this would be an unfunded impact upon GPD. So I think the onus is on the individual to know when their license is going to expire. I mean, we do that for driver's license now, and registrations, they don't mail them out anymore. So I would submit that on line 17 through 28 might have a resource impact upon GPD. And I noticed on page 10, line 16 through 27 about trying to cover as many circumstances under which a person would not be permitted to carry his weapon or concealed firearm into their place. You might want to include some other general language that allows any facility that, whether it's public or government, to generally, if they decide to prohibit weapons here, because you've only identified 7 settings, and it seems to me that if I have a business, I should be able to prohibit people from having their firearms on my premises if I want to, and you don't necessarily cover that. So perhaps some general language that says, the owner of a premise may prohibit that and have those necessary signs up. I mean, once you start putting this into law, then everybody's going to say, well, it's not on the list, so I can walk into the theater with it. I don't know. I think maybe the owner should be able to decide that for themselves. It's something to think about. It's a policy call. I'll leave that to you. And so that's more of our technical input into the statute, but we support the statute, which would objectively provide for law-abiding folks to receive a concealed firearms license, and just ask that these all the technical issues that are raised by people to make it a better statute be considered. Thank you.
Thank you very much, Mr. Tadinko. Before I open the floor, I'd like to, if there's anyone else in the audience who would like to provide testimony on this particular measure, I'd like to invite you up to the table. Aside from that, Senator Tonieta, any questions for members of the panel?
No, Mr. Chair. I'd just like to thank them for their input, and once again, the Chief of Police for his testimony, and the AG, and continue to work with the committee on Bill 296 also. So, thank you, Mr. Chair. Thank you to everyone.
Senators. Mr. AG, please, if I can just ask you. Yeah. Speaker Pangilinan?
Phil, you mentioned, of course, the background check and so forth. Are there any of the states that allow this must issue or allow concealed weapons require applicants to be published in a newspaper or journal? I go back to, I don't know why, but we require marriage license applications to be published in the Daily News or in the newspaper, because the background check process is just so, I don't know, it's not perfect. It's very, very far from perfect. And so, given this issue of some of the currency of training, the background on probation, if you pass it for 3 years, you're okay. What would be the general feeling of requiring applicants of concealed permits to be published in the paper as a condition?
I don't know the answer to that. You asked whether I knew of any jurisdictions that require that.
If my neighbor and I have been in dispute
know.
for many, many years, he keeps threatening me, but he doesn't have a gun. Then all of a sudden he goes and applies for a gun. Man, maybe I should be worried. So
again,
that kind of stuff.
I don't know
I'm
the
just
answer.
asking.
I don't know the
and
answer.
issues like that, I think deserve some kind of maybe discussion and feedback from the responsible gun donors. So I'm inviting Stan to come back up.
I hear a lot of other people who want to answer your question. I simply said I don't know about other jurisdictions.
Mr. Gibbons?
There was recently a case, I want to say it was Georgia, where a sheriff refused to give the listing of his county's firearms owners, not just concealed, but firearms owners, to the newspaper, and the newspaper took him to court and lost. The general consensus, I believe, is that when New York published, the paper New York City, where New York published a list of all of the gun owners, what you're doing when you do that is you're telling every criminal that wants to have some guns, well, here's the house to go to steal the guns. Just, make sure they go to the movies or they're working or something, and there's the house that's got the guns to steal. And the same thing when we talk about we don't want to carry open because we become a target. Well, if we've published it in the newspaper, well, Bob Gibbons is a concealed carry, you've just negated the fact that I'm concealing carrying because everybody knows I have a gun now. So again, I'm a target again.
No, I'm not talking about. I think once you pass that, I'm talking about application. So, just when you apply, whether they approve it or not, I'm not saying publish the approved applications. Just publish so that you can get some your neighbor's input. I guess I don't know, or your boyfriend that's going through where you're going through a divorce and your husband's telling you all this stuff and there's nothing there, but he's he's making threats and so forth, and against you and your new boyfriend, and all of a sudden we find out he's applying for a gun. So that can give some kind of feedback through the process. Background check. That's
background checks are required.
Yeah.
Mr. Wilson?
Background checks are currently required to get your firearms ID card, period.
Okay.
And so that is being done. And the fact is, if the government wants to publish that list, I think they should issue me a sign to put in my front yard that says, Ben doesn't have a gun.
Yeah.
Yeah. So the
That's
criminals
easy.
can go rob you and not me.
Yeah, that's fine.
It's not. That's not.
They have been. They have been coming to my house and not yours.
They've come to my house about 6 or 7 times, but not in the last 3 years.
Yeah.
But pretty much every responsible gun owner, and according to testimony, courts have withheld that that's not reasonable. The right to own a gun is in the Constitution, and so that if you have potential enemies and next door neighbors, you should just presume that they have a gun. I mean, you can get a gun. If you have a clean criminal record, you can own a gun. You keep it in your house. You can't carry it on your person unless you get a concealed carry permit, which is another process. But I think it's a terrible idea to publish the list of applicants.
So maybe not the concealed, but just gun.
I
Even
think
that.
it's a terrible idea to publish the list.
Okay. Thank you,
Either
Stan.
owners or applicants
I
or
hear
whatever.
you. Thank you.
Thank you, Mr. Wilson. Just a minute, please, sir.
Yeah, Senator, I just wanted to point out that the stupidity of that when it happened in New York was that
Mr.
yes.
I'm sorry, if we could just speak into the mic.
The stupidity of that New York paper doing that was that it identified every single law enforcement or person that was required to carry a weapon. It showed where they lived. That means that every criminal that had been arrested by a cop, a police officer, an undercover agent, their homes, their families were now targeted.
Well, I don't want to publish the addresses.
No,
But I know you can
that's
get
what
access.
they did.
Once you know who they are,
That's what they did.
if you want to find them,
and
then
see
you have methods to do so. So I understand.
Yeah, I mean, all it does is it just opens the door for criminals to go and see. It's stupid. Yeah, I mean, it's dangerous. I don't think the police officers would like to have everybody know where they live.
Yes, I would just say that we've never had any FOA requests for the listing of those that have been issued a firearms identification card, which is the first step. We haven't had any FOA requests. If we had a FOA request from either the media or from any individual saying we want a listing of just their names of who's been issued a firearms identification card, of that firearms identification, we always coordinate with the Attorney General's office on that, whether that's releasable and something like that.
Mr. Tenorio?
I would ask one question. To what purpose would it serve? And there is a potential for violation of the Privacy Act of 1974 by doing so, which would put our police department in violation of federal law and subject to potential civil and federal suits.
Well,
So again, I would ask, to what purpose would that serve
The
to
purpose
publish
is
that information?
so that if I have a neighbor, as I said, who has been, not a good neighbor, we kind of get into it every once in a while, and so forth, and then all of a sudden I see that he goes and applies for a gun, then I need to get notice that now he has a more effective way of, settling that argument with me, and he may be unstable. And if you can't tell whether the person's unstable or not, I mean, look at what's happened with these, and it's hard. It's hard to decide that that person is not unstable, but at least we now know the people that he's associated with that, okay, I think this guy's unstable. I better tell the chief of police, make sure you check his mental state, that he provides a certification from a psychiatrist or whatever. You know what I mean? So it enhances the background check over and beyond the current official records, and provides provides a community record of that person and his relationship with people in the community.
I would submit then, Senator, that we have that process in place where if an individual has been threatened by their neighbor or they feel that they're threatened by their neighbor, then they can report it to the proper authorities that they have a concern, then it could be looked into.
But that doesn't show in the background check.
If there's an official report that an individual was reported for having threatened someone, then that would show up in the background check because there would now be a police record of that incident where it was reported to the police and the police had to go.
I think this is saying for those that are convicted, not those that have a charge against them or a report. Because even a police clearance doesn't show an arrest.
Well,
it
by the
shows
same
only a
token, if they
conviction.
were arrested, sir, then they wouldn't be able to own a firearm to begin with, so they would not be able to apply for a concealed carry weapon permit because they're not eligible.
Is that what's in the background check requirement now?
I would have to defer that to the chief of police on what their procedure is.
Sure.
The procedures for the background check of any individual coming over and applying for a firearms identification so that they can have a firearm is they have to fill out a particular application which asks several questions. They could be charged for unsworn falsification if they are deceptive or put something that's false on that application, and it ranges from have you ever been charged for a misdemeanor, felony, have you ever been convicted, and it has those.
But not have you ever had a report filed against you?
Well, that's where it says have you ever been charged or for a misdemeanor, I believe, or for a felony,
Charged by who? By
like
at the Attorney General's office?
Arrested by Attorney General's
right.
office.
So no, this is I've reported free burglaries. I've charged people with free burglaries. No, but nothing's happened.
And the continuation of that is their fingerprints are taken, and then after that, then it's sent off to the Federal Bureau of Investigation for a National Crime Information check on them. Which is a nationwide database that the FBI has that can even determine whether they're a military AWOL, absent without leave, or anything in the terrorism database, or have any charges pending against them in any of the other 50 states and territories.
I'm sorry, Mr. Shabo, if you can speak into the mic, because everything is being recorded. I apologize.
If you look at the statistics, I think you'll find that concealed carry firearms owners do not attack, they defend, and that we don't have a record of concealed carry firearms owners who have gotten concealed carry permits so that they can attack their neighbor. And then the other thing is that if you have criminal intent, you're not going to take a NRA training course and get registered and announce to the community that you're a concealed carry person, or announce to the police department. You're going to get that firearm illegally. So and that's also statistically proven. So I think that the senator's concerns are not very strongly founded.
That's the nature of the public hearing process, so that we can share perspectives. So, Mr. Gibbons, I noticed you grabbed the chair. If you would like to make some final comments.
Senator Pangilinan voiced his concerns or his desires to have the name published of an individual that had applied for a concealed firearms ID.
I'm not expressing a desire. I'm asking a question.
He just posed a question.
Okay, you posed a question.
To see whether or not it makes sense and what is the reasons why. Does this happen in other jurisdictions? If it doesn't, why not? And so forth. So I'm not stating a position that I'm going to amend the bill to require publication. I'm asking, is that a good idea or not?
Okay. To answer your question in short, no, it's not a good idea.
And I could see by Stan's vociferous charge at the table here to tell me.
Yeah, it's definitely not a good idea. Sorry.
Thank you.
Thank you very much. Yes, Mr. Hickenbottom.
Senator, I know that we've already talked about it many times, that in this national identification check, Guam's got some of the most restrictive rules and laws that we have in the States. My recent purchase a year and a half ago, though, every time you go to Corrales and buy a weapon, they're not going to sell you a weapon until they do a NIC check. that means they go all the way to the FBI. Okay? Like the chief says, that NIC is up to date. It's kept. They have access. If you walk in there and say, my buddy next door, he's weird. Well, he's going to may not arrest him, but he's going to know. He's going to have a record, right, Chief, of who is suspicious in his area, and he'll watch him. And if that person then goes and tries to buy a weapon, the chief will know. I mean, the NIC is, this whole thing is going nationwide about trying to push for a background check is stupid. Because we've had the NIC in place for 25 years. In the 90s, when I was selling weapons from my business in Washington State, the state law there for pistols was that I had to call and do my NIC check. I had to fill out a form with the state of Washington. I had to submit it. I had to wait 3 days. I had to get that follow-up from the police in Olympia. I had to get the NIC check. Then I could release the weapon. That's been going on for 25 years. There's no reason for a background check. It's already in place when you buy a weapon. And here, because we have such strict laws, every time you buy every weapon, they're going to recheck you. Every time you get your renewal, they're going to recheck you.
I'm saying that, that also when you look at the shootings that have occurred in the public places and so forth, in a lot of them, guns were bought legally.
Yeah.
Guns were bought with a NIC check. Guns were bought, and the stability of that person was never checked. And so that's what occurred. It's not I mean, in that respect, it's not the gun. It's the guy carrying it.
That's a
so
societal issue.
Exactly
where
my
you have to
point.
address the mental
And
health.
so what I'm saying is, shouldn't society be more involved in making a determination whether that individual is legally stable, is mentally stable to own and carry the gun or have access to that gun? And that's not the debate on this bill, but and I'm sorry we're kind of getting into that.
Well,
but those are some of the issues and concerns I think that we all have to face and resolve for ourselves. And I thank the input here. I think I've received some very good input and certainly a lot of education when it comes to guns and gun ownership, because I'm just, that it hasn't been in my background to be able to deal with these. So.
I think that if some publication or public input prohibited people from owning a gun, I think that very few divorced men would ever own a gun. Period. I mean, I'm not sure that I think the system is in place. And in fact is, one of the debates nationally is to require the background check that gun stores have to do with the ATF. It's not the FBI. It's the ATF. Every time I buy a gun, the person I'm buying from, the registered gun seller, I fill out a form. He calls the ATF. He calls it in, and he gets one of 3 words: no, hold, or proceed. And if it's a proceed, which it normally is, then he can transfer to me, and I have 3 days, I think, to register at the police department. The other thing that Guam has that for example, the issue is shall gun shows where people are trading among themselves. That requirement doesn't exist in most of the states. It exists here. I can't sell a gun to anybody unless I bring myself and my gun and the certificate of registration for that gun to the armory, and we fill out paperwork, and then that person goes to the firearms and ID section in ITC building and re-registers the gun in his name. So we have some really good, strong controls in place. And so it really isn't the legal registered gun owners that we all should be worried about. It's the people that are getting them out of the back of somebody's pickup truck or out of Ben's house when they break in.
Exactly. The ATF gun tracing program is a very strong thing that we do. We actually had a policy in place in 2004 to implement gun tracing policy for all firearms that are confiscated and for all firearms that we hope for safekeeping. And sometimes we would possibly even get a hit on it. But and that just covers any particular gaps because as people do these transactions and they're buying a gun owner to another gun owner. Sometimes you just never know that the other gun owner who's selling it to another one, if they're for nefarious purposes, if they're just trying to do some kind of trick. We've had people in the past where they sold a car, you found out that car wasn't really the sticker was a fraudulent plate or it had a different sticker. So for that purposes, those are just the gaps that we'll try and cover with that gun tracing policy that we have at the police department. In the event someone gets a hit, it's an investigative tool that we can use.
Thank you, Chief Bradley. We do have one more individual, and Mr. AG, I do have a follow-on question for you, but please, if you can identify yourself and proceed with your statement.
Yes, my name is Sylvie Alvarez, and I just wanted to state, in regards to publishing names, Guam is small. If you publish somebody's name, they don't need an address. They don't need a phone number. They'll most probably figure out who you are. As a female, I don't want people to know that I'm carrying concealed. I want to, it's my right. If I pass all the requirements, I should be able to carry it and be a responsible person with it and not have to have everybody know and my neighbor know if I'm carrying or not. That's a privacy issue that I have. Thank you.
Thank you very much, Ms. Alves, and thank you very much, folks, for your testimony this morning. Just a quick question, Mr. AG. The statements, and Chief, I appreciate your perspective in terms of enhancing the legislation, but there's one recommendation that you have, or two, that reads, the holder of a concealed firearms license who is formally charged with a crime punishable by imprisonment exceeding 1 year shall have his or her license revoked pending the adjudication process. And then it continues, in the event of a court conviction, the license shall be revoked permanently. Now, when someone is charged, isn't that where the judge has the discretion to make a decision whether, in fact, should that individual have a firearm that
by the way, I outed myself by saying I have a concealed, but I don't mind because I put too many people in jail, so it's best they know that. It depends. Like in the family violence law, statute, there's a requirement that their license, their weapons be turned in, and all of that. I didn't quite get a chance to analyze the chief's suggestions about why he would want to temporarily suspend it while you're pending charges, but currently, like especially in a domestic violence situation, the law on the books requires that you turn in all your weapons anyway, including, I believe, your firearms license. So, especially in the domestic violence situation, so the statute covers that. But I noticed when I read the chiefs real quickly, he just said any crime punishable by 1 year or more, which would be usually in the felony section. So, but I haven't given it any more thought than that.
I was just under the impression that the AG's office, as well as the judge, take those items into consideration. But
yeah,
I guess
again, especially in the domestic violence situation, those are the requirements, and automatically those are requested that they turn all those in if they happen to have it. So, upon when you're formally charged, your peer. Yeah, it's when you're formally charged, because when you're arrested, there's no judge there, so it's when you're in court, and then the judge for your first time.
Okay. Thank you very much, gentlemen, for your testimony this morning. And once again, the committee will be accepting written testimony subsequent to this public hearing on Bill number 296 for the next 10 days. And the committee does reserve the right to call for a follow-on, a continuous public hearing on this particular measure should the committee feel it necessary to ensure that the public is properly informed. So that concludes our discussion on that particular legislation. We're proceeding on to Bill number 298, which is relative to punishment for the delivery, dispensing, manufacturing, and importation of controlled substances, which may be cited as the Methamphetamine Incarceration Reform Act of 2014. If I can invite the following individuals to the front, please. Mr. Gary, you're here already. Fred Bernalio, Chief of Police, and Mr. Phil Tedinko. Mr. Hickenbottom, if you can proceed. Just identify yourself for the record.
To make a stand that the stronger we can make the punishments for these drug-related crimes, the better. And the one thing that I saw in the quick read was we have a situation here in Guam. You didn't list marijuana. Marijuana is a dangerous drug. And I know we've got policies, we got all headaches going, we're looking at medical marijuana here. I think you're going to find, if you watch what's happening in Colorado and Washington, it's going to become a nightmare because traffic stops, the police officers cannot determine the amount of marijuana that's within a system, so they can't say they're impaired or not. These people out there are going to be causing a lot of damage and injuries to other people. So marijuana is not something to play with. It's a dangerous drug and should be included in this legislation. Now, when we go, if you want to go and play with the medical marijuana, that's a different issue. But you're going to see already that California's finding it's a joke. It's a nightmare, and it really needs to be tightly controlled. And just because there was a young man or whoever died recently and they put a bill in his name, that's great. But just because one person has an illness and dies saying he wants marijuana, it doesn't mean marijuana is good for everybody. Marijuana is a dangerous drug. It's a gateway drug. It's what starts everybody on every other drug. So we have to put it in there and give them the same kind of punishments. And we have to be extremely careful when we go and look at medical marijuana issues. So I strongly support this, but I would like to see it improved, strengthened, and I don't know, how would you deal with pulling somebody over a stone? How are you going to give them a ticket? Can you write them a ticket for being DWA? No. See, that's what they're finding in Washington. They get the people driving all over the state, drunk, and they're stopping them. They give them a ticket for drunk, but if they're on marijuana, you don't know how to determine how stoned they are. And it's happening in Colorado too. So it's a major issue.
Thank you very much for your testimony this morning, Mr. Hickenbottom. Gentlemen, if you can please excuse me, I was remiss to have the sponsor of the legislation highlight the purpose of this measure. Senator McCready.
Thank you, Mr. Chairman. Good morning, panel. Bill 298-32, also known as the Methamphetamine Incarceration Reform Act of 2014, increases the penalties for those who import or possess substantial amounts of methamphetamine, also known as the drug ice, with the intent of distribution, delivery, or manufacturing. Additionally, it does establish a mandatory sentence for imprisonment for anyone who's convicted of the second offense. This bill also requires that the consequence of bringing substantial quantities of methamphetamine and other drugs be printed on the customs form filled out by every incoming passenger to Guam. Every day we open the newspaper and watch the TV, and we see that people are being arrested for the second, third, fourth, and fifth times in some cases after so many chances to re-enter society. When do we say enough is enough? Increasing punishment for the worst offenders is a sign that we will no longer tolerate any person who brings these substances into Guam to ruin our families, our individuals, and our community. Mr. Chairman, the Guam Uniform Controlled Substance Act is Chapter 67, and after reviewing this with the construction of our legislation, we found that Chapter 67 needs to be entirely rewritten. This bill is a piece of legislation that I believe takes care of a huge problem that's plaguing our island, but I do believe it's a cumbersome process that we need to make sure we work together. So I continue to ask for your patience, Mr. Chairman, as we take this bill through the process, that I'm working closely with the Attorney General's office in trying to rewrite this chapter and trying to make sure that this bill has the proper teeth in it that will have the effect on people trying to bring ICE into our island, as well as the police department. So thank you for allowing me to speak on this, and I hope for the support and the confidence in moving this through and having a piece of responsible legislation. Thank you.
Thank you very much, Senator McCready. Chief Redadio?
Good morning. In behalf of the Guam Police Department, we hereby do support this legislation, Bill 298-32, a bill to increase incarceration for these methamphetamine dealers, and it sends a strong message, to the community in terms of, the problem of distribution of ice and how the implications of it, the impact on it. As a matter of fact, we have seen that with this problem of crystal meth and how the dealers have imported it in and distribute it out and sell it and take advantage of individuals who are consuming it, it leads to not only violent crimes but the property crimes. I wouldn't bet that the house, your house that was burglarized, Senator Pangilinan, has a connection to an individual who probably has a problem with the drug ice. We've seen a frequency of it. And it's not only just affecting adult offenders, but some of our youth now are exposed in these households. Even when I used to be a member of the drug unit, we come into a place and we're in the middle of a controlled buy or buy bus operation where we take the ice dealer down, and in another room is where several kids are in just to keep them busy while a drug deal is going down with crystal meth. And certainly when some of the recidivists, who keep coming out into the street again after they've been arrested for previous drug offenses of dealing, this sends a strong message. And I've had an opportunity not only as a police officer but working in the correction system, to see some of the longer time that they're spending behind bars and going through the correction system as adult offenders that the crime isn't going to pay for them, because now they'll have a longer sentence for the cost and damage they did in dealing ice in our community. Thank you.
Thank you very much, Chief Redadio. Mr. Zedinko?
Good morning again, Mr. Chairman and honorable senators. On behalf of Attorney General Rapadas and Office of Attorney General, we support the efforts made by the senator and the other supporting authors in wanting to improve the Chapter 67, the drug statutes in Title IX. In fact, we were working with Senator McCready, and we see this as an opportunity to address the not simply this specific section, but also most of Chapter 67. There are some problems with our statute. For example, the definition of narcotic drugs in the statute presently does not actually include methamphetamine. So there are just basic stuff like that we need to address. So we see this as an opportunity to continue working with Senator McCready and this body to update and improve Chapter 67 and perhaps expand the scope of this bill to address some of the other problems. And so it's my understanding that we wish to continue that, and that's our input. And if I was wondering if I could be excused early. I have a 12 o'clock to get to, unless you have some important questions. Thank you.
Thank you very much, Mr. Tadinko. Unless there's any questions for the Deputy Chief Attorney General or Chief Redadio? Any final comments, Senators? Then this concludes our discussion on this particular legislation. And once again, the committee would like to highlight that, in fact, we will continue to receive testimony on this and all the other measures that were entertained today for the subsequent 10 days from today's date, and also for the information of the public because of the nature of some of these provisions. What we will also do is keep the option of a continuing hearing within that 10-day timeline, so that in fact we will continue to keep the public informed. So thank you very much for all your testimony, and Senators, thank you for joining us today. This concludes our hearing.